Delivery of order, item number 1.
I have formulated substantial question of law. I have formulated a substantial question of law and fixed the matter for hearing on 13th of August.
13th of
August.
August.
And there is a IA, Mr. Dekha.
Yes.
The execution will remain stayed till.
Execution have not been filed.
Okay. Then no IA. Yes. Yes, Mr. Chetri.
Malhotra, I'm extremely sorry, Malhotra. Otherwise, I would not have come before Lordship, Malhotra. Because the trial will be commenced from 4th of July, Malhotra. Already, my case has been reserved for judgment on 25th of
Okay.
May.
Okay.
So only for up to that or till that time, Malhotra. Only that trial may not be commenced, Malhotra. Otherwise,
Before 4th, I will deliver it. Still, there are 2 days for vacation. Before 4th, I will deliver the judgment.
then I need not mention, Malhotra. I'm extremely sorry.
Yes.
My lord, we both side, my lord, joint prayer, my lord, as regards item number 40, my lord. Here, my lord, almost, my lord, conclude, my lord, we have to submit our written argument, my lord.
Yes.
6 PM we will submit written argument.
Okay.
So maybe call it 2 PM. Just submit.
Item number 40 at 2.
Okay.
Materials, my lord, we have filed in CRP IO, my. Some urgency there that may be listed on day after tomorrow, my, on 25th.
Okay.
Okay.
My lord. On behalf of tomorrow, there is urgency solution.
When have you filed?
Proceeding yesterday.
Okay.
This is a Lordship, in item number 35, we have filed a written objection that may kindly be brought in record, madam. I request.
Call for the written objection.
Deeply obliged, madam.
But filed on RSA on 19th. Execution is going on, Lord. If possible, tomorrow, Lord.
I said, wow, you fresh filing.
Fresh filing on 19th we have filed, but execution is continuing. Maybe
Okay, tomorrow.
Lord.
Tomorrow.
Much of.
May please, Your Lordship. Lordship, I beg to mention item number 45 with the consent of other side.
What is the prayer?
Adjournment, Lordship.
You have to say it. Otherwise, how I will know what you are going to mention?
Adjournment, Lordship.
Had Mr. S. Pegu, Learned Counsel for S. Pegu, Learned Counsel for the respondent or appellant?
Appellant, Lordship.
Appellant who prays for an adjournment on the ground of personal difficulty.
There may be fixed, Lordship, after vacation.
He submits that he has informed Learned Counsel for the respondent regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed 17th of September. Yes.
This matter relates to release of the amount executed by the insurance company. Matter may be listed on 25th.
Okay.
May it please your lordship. Your lordship, I beg to mention for listing of an RSA for hearing, lordship. Kindly a date may be fixed in the.
Then go to registry. Pray before registry.
Obliged.
Yeah, please, your lordship, praying for listing of your active day, your lordship. First of all, motion matter, your lordship. Any day before vacation, your lordship.
25th.
Please, Lordship, I have filed one IA Lordship on 27th February, but till that matter has not been listed. So, Lordship.
Regarding what?
For in a connection of the MSc appeal, Lordship, for releasing the amount. Already insurance company has deposited the amount. But we.
A week or the date before vacation. 25th.
25th.
25th June.
25.
The lordship, mention matter for listing. It's a section 11 petition. There's a slight urgency in the matter, your lordship.
Section 11 of?
Petitioner. Urgency is that we have blacklisting orders have already been passed by the other side. Any date before the vacation,
Before vacation,
any date, your lordship.
before vacation, 25th.
Much.
Please, your lordship. Lordship, I'd beg to mention an RSA for listing, lordship, day after tomorrow, lordship.
For-
It's a fresh filing, lordship. The execution proceeding is ongoing, lordship.
When have you filed?
Lordship, on last month, lordship. It has been listed twice, but it did not reach, lordship.
Okay, day after tomorrow.
Obliged, lordship.
May I please, your lordship? Lordship, we beg to mention for listing of a CRP matter, your lordship, in the admission column.
What, when it was last listed?
Lordship, on 4th of December 2025.
What is the urgency?
Lordship, it was, as per the last order, your lordship, it was to be listed after 2 weeks, but the matter was not listed.
After vacation, 22nd July.
Obliged, lordship.
It is your lordship. I'm seeking your lordship permission for listing of a CRP on day after tomorrow, my lord.
Have you filed it?
Yes, filing.
When?
Yesterday, my lord.
Okay. Okay.
Yes. I am praying for listing of a case for order after application.
17 July.
Obliged.
May I please, lordship, I beg to mention also CRP IA, lordship, day after tomorrow, lordship. For title, against the title execution, lordship.
Okay.
May I please, lordship? Lordship, I pay to list the matter for yesterday we filed in miscellaneous first appeal. So kindly list the matter after vacation.
After vacation.
Please, lordship. I'm praying for listing of an RSA in the orders column, your lordship.
After-
There's an interim operating in our part, and the next day of execution case is on the execution case is stayed, and the next date is on 27, 2026. Next
After vacation. 22nd July.
month. Lordship, the execution is stayed, but we need to submit the updated interim order, certified copy of the interim order
Where?
on before 27, 2026.
Whether an interim has been given, interim order has
It
been
was
passed,
given by your lordship on 17/12/2025.
then what is the problem?
We need to submit the updated. It was not listed after that. We need to provide the updated interim order.
Why? It is operated
It is operating, but it was not listed, your lordship.
after vacation,
Just after vacation.
22nd July,
Matter is fixed on 27.
22nd July.
May I please, your lordship, I beg to mention listing of two MFAs, my lord. It's a 2016 MFA.
After vacation,
My lords, we give any date.
22nd July.
Grateful, man.
May I please, your lordship, I beg to mention for CRP IO, listing of a CRP IO, your lordship, for tomorrow, your lordship, possibly.
When have you filed?
Your lordship, we have filed it by today. It is fresh.
Day after tomorrow,
No, your lordship, then for 26, because day after tomorrow, the conducting council is
26th,
file your list.
26th
June.
June. Okay.
Wait, please, your lordship, I beg to mention item number 36, 37, 38. Your lordship, consent has been taken from the other side. As the contending counsel in these matters is ill, due to which your lordship may fix.
What is your name?
A Deb.
Heard Mr. A. Dev, learned counsel for the
Appellant.
appellant, who prays for an adjournment on the ground that the conducting counsel for the appellant is indisposed. Appellant is indisposed.
Your lordship,
You are appearing for?
appellant.
He submits that he has informed the learned counsel for the other side regarding his prayer for adjournment. Hence, prayer is allowed. Let this matter be listed.
In the last week of July, your lordship,
22nd September.
your lordship, a shorter date.
22nd September.
Should only on the, in item number 37, a shorter date may be given.
Item number 37. 15 September.
Much of.
Please, move on. Item 2.
May I please, your lordship? Lordship, the transfer petition, I have filed a transfer for transferring the matrimonial proceedings from Nagaon to Gauhati. The petitioner herein is the wife, my lordship, and she is residing here along with her minor daughter, who is residing in, who is studying in class 7, and along with her mother.
Miss S.G. Barua, the learned counsel for the petitioner. This application under section 24 of the Code of Civil Procedure 1908 has been filed by the petitioner, namely Srimati Gauri Devi, praying for transfer of the matrimonial suit within bracket D number 136/2025 pending before the Court of London, Additional District Judge number 1 Nagaon, to the Court of Principal Judge Family Court Kamrup Metro. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 12th of August. At what stage it is pending?
First day, my lordship, I'm praying for. The grounds are that, my lordship,
Considering the averments made in the petition as well as submissions made by learned counsel for the petitioner, further proceedings of matrimonial suit D number 136/2025 pending in the Court of Learned Additional District Judge Nagaon number 1, Additional District Judge number 1 Nagaon shall remain stayed till next returnable date.
oblige, my lordship.
May I please, Lordship? My lord, as per the last order, my lord, today is the date fixed for consideration of the petition. All, my lord. Yeah, my lord, nutshell is that, my lord, after
You have
comment,
filed written objection.
no objection has
So,
been.
my lord, I have gone through the entire petition. Only one thing I would like to submit, that is the issues. That my friend has already annexed everything except the issues. I will file and I have made a typed copy. That is not on record. So I have prepared.
Is not on record.
Not in record. Otherwise, everything is there. That is why we have not troubled your lordship with objection.
Okay. Yes, what is this?
My lord, no, that are the issues, my lord. That will come subsequently, my lord. The main issue before your lordship is that, my lord, after commencement of the trial, whether learned trial court was justified in allowing amendment after cross-examination of 3 persons from the PW side, my lord. There is the 3 witnesses that have been examined and we have cross-examined, my lord. The moment it was brought out, my lord, in the cross, my lord, they filed the amendment petition. That is my case, my lord. The imping order, lordship will see at page my lord, 263, my lord. May I read, my lord?
Yes.
It is the
Yeah.
annexure 8, my lord,
Yes,
which
please
is
read.
put under challenge, my lord.
Please
May I
read.
read, my lord?
Yes.
I have heard the both sides, the petition number so and so, plaintiff under order 6 rule 17 section 151153 of CPC for amendment of the plaint. The petition is the stated that he has filed the title suit against the opposite party, declaration of right title interest of the scheduled land. The petitioner stated that the presently suit is fixed for examination of official witnesses. The petitioner further states that the schedule of the plain village in the scheduled land is situated mentioned in Kahilipara Nonke village falling under the Beltala Moja. Same has been mentioned in the sale deed number so and so. That is their sale deed they have mentioned. The petitioner stated that the subsequently from the perusal of the draft Sida, they had come to know that the peasants village is shown as number 3 Nonke Gao instead of Kahilipara Nonke. that same needs to be amended in the plaint. The petitioner state that due to the passage of the time, settlement operation Kahilipara Gao was divided into three parts. Non-K Gao, number 2 Kahilipara Gao, number 3 Kahilipara Gao. Therefore, the petitioner has prayed that may be allowed to amend the schedule of the plaint, showing that the same name of the village schedule land number 3 of the Kahilipara Gao. Same is required to be proper adjudication of the suit. The opposite party in their objection during the course of hearing stated that the petition filed by the plaintiff is not maintainable in the law and facts liable to be rejected. The engaged counsel for the opposite party has also stated schedule of the land mentioned in the plaint mentioned in the sale deed number of 1985, due to which the amendment is required. The engaged counsel opposite party has also stated that the petitioner has not submitted any document to show that the village was divided three parts after 1995. The petition of the amendment was filed merely to fill up the lacuna in the plaintiff case. Therefore, the opposite party prayed that the petition filed by the opposition rejected, and I have perused the case record. Necessary provision of Order 6 Rule 17 provides the amendment of the pleading. Upon bare perusal of the said section, it can be said amendment of the pleadings can be made any stage of the proceeding of such amendment shall be determined the real question of controversy in the facts. The perusal of the amendment of the submitted along with the petition shows that the scheduled land mentioned in the plaint falls under village number 3, Kahilipara non-case. Since the suit is brought by the plaintiff, the burden providing the schedule falls under number 3 Kahilipara non-K village would always be upon the plaintiff. Further, since the issue relates to the village schedule land, the schedule situated in the amendment plaint, that would be necessarily proper adjudication of the suit and also determine the real question and controversy. Further, allowing the proposed amendment would not adversely affect that shall be sufficient opportunity to file the written statement against the amendment plaint, and they shall also give the sufficient opportunity to cross the examine so and so. Considering the cause of the so and so allowed that the amendment plaint is fixing so and so case is disposed of. Now, Lordship will see after commencement of the trial matter, and first they filed the title suit in the year 2017 at page Lordship will see their page 16, my lord. They file a title suit. This is the title suit, my lord, page 16. And they ask for the prayer, my lord, that your lordship will see at page 22. Page 16 is the plaint filed by them, and 22 is the prayer portion. It is therefore prayed that your honor would be graciously pleased to pass the decree so and so, declaring the plaintiff right so and so recovery and permanent injunction and cause of this. There, my lord, they had apprehended schedule, page 23, a plot of land measuring 12 lacha, 15 lacha out of 1 kata, 15 lachas of the Morse Valley described, which is covered by dag number so and so in the district of Kamrup, situated Kahilipara non-K. Lordship has come across.
Yes.
Kahilipara non-K. Then, my lord, they filed list of documents, page 27. That is way back in 17, my lord, 2017. There, my lord, they have relied upon their sale date, my lord. Operative part of the sale date is the schedule of the land is mentioned at page 33. The more bhal copy diya nai. It is a registered sale deed, my lord. Allegedly, they have got the land, my lord. Page 33. Total land of so and so 1 kata 11 lasa covered by dag number 514 KP Patta number 27 situated at Kahilipara non-K village. That is their sale deed, my lord. Then lordship, they have, while passing, my lord, filing the title suit, they've got obtained one, my lord, a certificate from the revenue authority. Revenue authority, my lord. That the vernacular part lordship will get at page 35. Now, my lord, it is from the certificate issued by the revenue authority showing as 1 number Kahilipara. Lordship has got it, my lord.
What certificate is this?
It is the, my lord, যার জন্য settlement officer given. Assistant settlement officer issued a certificate. It is like this, my lord. Gauhati Purna Bandobasti Padhikargir Karjalay, so and so, Gauhati, so and so. 11408. They are showing, my lord, প্রমাণপত্র দেয়া হল যে বেলতলা মৌজার 1 নম্বর কাহিলিপাড়া গাঁওর খেয়াস মেদি পুরনি 27 নূতন তিনি পাট্টার সোয়েনসো নূতন দাগ হল. This is the certificate. Thereafter, my lord, they have also relied one Jamabandi. Draft Jamabandi, it is, my lord, seems to be. Lordship will see at page number 37. Now, my lord, it is reflected 3 number Kahilipara NK. Lordship has got it, page 37, extreme top right, my lord. Kamrup Jala Beltala Moujar 3 number NK Gaur 73 number Dagor Tikar Biktite Nokol. Now, Lordship has seen 3 number non-K. Thereafter, my lord, they have issued annexed another document that your lordship will see page 39. Lordship has got it, my lord, page 39, vernacular part. Now, my lord, it is Kahilipara non-K. Then, my lord, it took Kifar Vastu. And they, after paying the revenue, my lord, it is seen, my lord, page 41. প্রমাণপত্র দেয়া হল যে বেলতলা মৌজার 1 নম্বর কাহিলিপাড়া গাঁৱৰ খিয়াৰাজ মেদি পাট্টা 27 পাট্টাৰ লগত সোয়েনসো টকা খাজনা দিয়া হল. That is, my lord, page 41. Thereafter, my lord, in the case I filed a counterclaim also, WS also. That your lordship will see page 22. And now, very interestingly, lordship will see the official witnesses. Before coming to the cross-examination of witnesses, I like to draw lordship's attention at page 54. This is the certificate given by the settlement officer after circle officer, sorry, my lord. After field verification, page 54. অসমীয়া পঢ়ি দিয়া পঢ়া ময়ো পঢ়ি আছো. উপৰোক্ত বিষয় মৰ্মে জনাও যে যোৱা 28/4/15 তাৰিখে আৰক্ষী বিষয়াৰ লগত যুটীয়া তদন্ত দেখা যায় যে দিছপুৰ ৰাজহুৱা চক্ৰৰ অন্তৰ্গত বেলতলা মৌজাৰ 3 নং কাহিলিপাৰা লৰ্ডশ্বিপ 3 নং কাহিলিপাৰা খেৰাজ মেদি পাট্টা নম্বৰ 7 পাট্টাৰ 72 নম্বৰ আৰু 73 নম্বৰ দাগৰ আৰু চৰকাৰী 181 দাগৰ অংশ জমিত শ্ৰী বিশ্বৰঞ্জন বৰা লোকজনে অসমাহী ঘৰ সাজি আছে। শ্ৰী বৰাই কোৱা মতে 17-18 বছৰ পৰা উক্ত জমিতে তেওঁ বসবাস কৰি আছে। নথি মতে 72 আৰু 73 দাগ জুট পুৰাণী 514 দাগৰ
Where is the amendment application?
Lordship, I'm coming, my lord. Before coming to the amendment, I like to show one thing, my lord. Before coming to that, my lord, why amendment has come into place,
Yes.
my lord? That I want to like show your lordship. Attention, my lord. Lordship, kindly turn to the 165, my lord. 165. That is the cross examination of and re-examination of the official witnesses. Operative part, lordship can skip, my lord, page 166.
Yes.
May I read, my lord, only operative part, my lord. Today, before the court, that's the cross part, my lord. There is no name of the Purnima Bhattacharya as
Now what
recorded.
you want to show?
I'd like to show
You
lordship.
come directly to the point. What you
To
want?
the point, my lord. Yes, that paragraph, that one.
Yes.
Today, before the court, there is no name of Purnima Bhattacharya as recorded Pattadar in the draft Chita, which I have brought to the court today. In the Chita, position of a person not reflected. In the Chita, dag number so and so, name of Nikhil Ghosh, Pyali Ghosh is not mentioned in the draft Chita. The name of key is recorded, my lord. It is not mentioned in the draft Sida. The name of Nikhil Ghosh, that is the respondent, my lord, is recorded on the basis of the position over the land. Title page of the draft Sita, which I brought today, reflects the name. Same belongs to number 1 village Kahili Para. He himself said, my lord, the land mentioned in dag number so and so under village number 1 Kahili Para Nonke. Number 1 village Kahilipara pertaining to dag number 73 old so and so patta numbers name of the Nikhil Chandra Ghosh has not been recorded in the patta of the dag number so and so. In the chief, though I have stated that I have brought the draft Sita of number 3 village Nonke, same is not correct. He himself saying, my lord, though I have stated in the chief, but it is not correct. If it is not that Kahli Para, it is or not fact that I have not brought to the record. Now, lordship will see next cross part, my lord, in the same page, my lord. Draft Sita, which I brought before the court in respect of the number 1 village Kahili Para, as reflected from the page of the draft Sita. However, exhibit 3 is related to village number 3 number village number Kahili Para non-K. After that, my lord, they have come for village number 3 and K. Then, lordship, I have not found the name of Nikhil Chandra Ghosh, son of Pyali Chandra. I have not seen the rectification in the draft Sita I have brought today, exhibit 3. I have also not found the rectification. Both village number 1 and village number 3 are different. He himself saying, my lord, is the different. Then lordship can come to the directly, my lord, is the another lot mandal, my lord.
No, what is your point?
Point, my lord, he has mentioned that this dag number does not area number. Their issue is only, my lord, NK3. Whereas
The plaintiff want to amend his.
no, plaintiff filed a title suit relying on the document showing NK
No,
number 1.
He wants to amend the schedule of the.
3, my lord. They have
Plain-
come into my land now. Now, why they want to come, my lord, after cross-examination, that I am want to show, my lord. Lordship, kindly give me some time, my lord.
You have taken sufficient time, but you have
Lordship,
not
my lord, the big
not
one.
yet come to the point.
Lordship, in the cross part of the lot mandal, he himself said,
No,
my
no,
lord.
Mr. Borbhuya,
My lord.
you first tell me what you want to establish.
I want to establish is that, my lord, after cross examination of their witnesses, they came to know that that land is not schedule 1, my lord. Now they said, my lord, it should be number 3, whereas settlement.
No, in the schedule they have mentioned Kahilipara non-K only without
Non-K
giving,
only, my lord.
without
Release
giving
number
any.
1. In the officer, my lord, official of
No, listen to my query. Where is their amendment application?
Yes, my lord. That I'm coming, my lord. Amendment application that your lordship will see. 239 starts from operative part is 255. 239 it starts, my lord.
Okay, now what is your point? That
This point is that, my lord, they have filed the title suit way back in 17 and they cannot come, my lord. Due diligence is not mentioned or reflected anywhere in the petition or could not have shown that it was my bona fide mistake or oversight. To that effect, my lord, I have come with the number of judgment, my lord. It has been clearly reflected, my lord, emphasized, my lord, how it is a due diligence. Now, my lord, that petition has been filed way back in my lord 24. Whereas cross-examination and the document page number 54, it has been shown year 2015. 54 is the settlement report. Now lordship will see the plaint has been filed. Amendment petition has been filed in the 24. Now lordship, to that effect, I have come, my lord, with the 4 number of judgment, my lordship. I like to rely, my lord, SCC 19 kitab to dia. Lordship, I am supplying only pinpoint, my lord. 19 to 1 number, na? LIC to আগত দিব।
CPC ঘূৰাই দিয়ক।
Lordship, in the first 2019, my lord, lordship will see page 332, my lord. Here, my lord said about civil procedure code. So and so, order 6, rule 17 proviso, amendment of the pleading after commencement of the trial. Not permissible except under condition stated in the provision. Burden on the person seeking amendment of the after commencement of the trial to show the due diligence. What is due diligence? There is another set of judgment, my lord. Lordship, I have given the, my lord, one type copy also, what judgment I am relying. And now lordship will see the what is due diligence. Due diligence to there. Now lordship will see second number, my lord, which I have given, my lord. That judgment I have to read, my lord. 2008 volume 5 SCC, my lord, page operative part of the page is 111 or 118, my lord, sorry. The word due diligence has not been defined in the Code of Civil Procedure according to the Oxford Dictionary edition 2006. The word due diligence means the careful and persistent application or effort. Diligent means the careful and steady in application of one's work duties, showing the care and effort. As per Black Law Dictionary, due diligence mean the conjugal effort to accomplish the something care, caution and attention and care required from the person in a given situation. Due diligence means the diligence reasonably expected from the ordinary exercise by a person who seeks to satisfy a legal requirement to discharge an obligation according to the words and phrase by the drain permanent edition 13A. Due diligence is a law means doing something reasonable, not everything possible. Due diligence means the reasonable diligence. It means that self diligence is a prudent man would exercise in the conduct of his own affairs. And that operative paragraph is 16, my lord. That I am not reading, my lord. Lordship, just to save the time of the honorable court, my lord. Now, lordship will see another judgment That is 2024, my lord, page 705, my lord. 705, my lord. I'm reading just operative part, my lord. Lordship can jot down, my lord. B, my lord. B. 705, Lordship has come across.
Yes.
B, my lord. Civil Procedure Code, Order 6, Rule 17, Proviso, Amendment of the Plaint, Permissibility, Factors to be considered, due diligence, burden to establish due diligence, lack of amendment cannot be allowed.
Okay.
That operative part, Lordship will see, and C also, my lord. Civil procedure so and so 19 limitation will come now, my lord. 59 Limitation Act amendment of the plain factors to be considered. Amendment relief is sought for when whether already stood barred by limitation. Initially the suit is filed for the participation, partition and separate position by way of amending the relief of the declaration of compromise decree bill null and void and was sought. Application for amendment of the plain filed 5 years 3 months
This is
would
not
not pass
relevant.
so and so. There, my lord, meaning thereby, my lord, though my lord, ratio of the law is laid down, my lord, due diligence has to be established. And in the impugned judgment, my lord, there is no any reflection or any whisper or any discussion that why it was taken so much time. If they have the knowledge of that very, my lord. 2015, 2017, they filed. It's suddenly after cross-examination, after commencement of the trial, my lord, Apex Court has said it cannot be, my lord. Another, my lord, judgment, lordship, just nutshell, I'm going, my lord. SCC 2009 84, page 84. There are. Here also, my lord, same thing, my lord, refusal of the amendment, exercise, my lord, how to be refused and bona fide, legitimate, honest and necessary amendments should never be permitted. Here also, my lord, it is against the plaintiff. It cannot be, my lord. Due diligence is lacking. Then another judgment, my lord, 24 Diana, 24 Kotok Disa. In the latest judgment, my lord, 24, which I have given is a lordship. Lordship can directly come out to paragraph 70, my lord.
Which judgment?
That LIC, my lord, the loose shade of lordship, like this, my lord. Lordship, kindly have a look, my lord. This type of, my lord, para 70. What are the parameters and how to
Para
70, my lord. I have already marked my yellow mark. I may be pardoned for that. In our final consideration to be summed up in order so and so, these are the guidelines has been given. See how, my lord, and what are the procedure, how it has to be proceeded in the amendment of the plaint in the latest stage. It has been guided. That is the holding field now, my lord. And another judgment, my lord, out of this one as civil. Etu disa, 902 disa, 2402 disa. And in the, if your lordship permit me to go back to again PW 1, my lord. Only 2 page I like to show, my lord. 1 page 120 and 39, my lord. Second paragraph. Exhibit is not my joint patta suit. Joint patta is the name of Shankar Bhattacharya Nikhil Ghose. I do not know the issue number of the joint patta. This, my lord, first he said does not know. Then, my lord, when the official witness examined, they said, my lord, it is a totally different line. The moment he said totally different, which I have shown earlier occasion, my lord, before your lordship, then, my lord, there also, my lord, the list of document also non-K. Why, my lord, they want to enter into my land, my lord? I am holding a some government land and that number totally different. And there is, my lord, as per the requirement of the law, my lord, which have been guided by the Honorable Apex Court, my lord, due diligence, there is no whisper statement or anything that why it has taken so much time. Now, my lord, they simply said on perusal of the draft Sita, they came to know. And whereas they filed the title suit, cross-examined, and other two witnesses also they brought in, official from the deputy commissioner and Lord Mandal. The moment they came to know that, my lord, and now, my lord, trial has already started, my lord. So my prayer will be that, my lord, the impine order cannot be sustainable because of the fact, my lord, there is no any discussion why, my lord, this jurisdiction has been exercised after commencement of the trial. It has hit directly to the which I have relied upon the judgment of the apex court, my lord. It cannot be, my lord. Due diligence cannot be because
Okay,
list of
okay.
document, just I'll conclude, my lord. The list of document which they filed at the time of that is, lordship, kindly note down the date 20 pass Nikki. This pass. No, case file kora too. This pass. That has been filed title suit, my lord, 25/2017. And to that effect, my lord, Mandal concerned circle officer, page 54, it is given way back in 2015, where they were sleeping. What is the due diligence, my lord? So in view of that, my lord, the impine order cannot be sustained. They cannot cover up the lacuna, my lord. And in the view of the judgment of which I have relied upon, my lord,
Yes, Mr.
it cannot.
My lord, I agree with the learned counsel for the petitioner that the schedule of my property, which I have stated in my, along with my plane, the lordship will find that here it is written as Kahilipara non-K village. And the defendant has filed a counter claim, which the schedule your lordship will find at page 66. Page 66 of their written statement comes counter claim.
Another long page. 66.
Yes.
Page 66, schedule B, mentioned in defendant date.
Schedule B, yes.
Schedule B, so and so dag number, patta number 27, situated at Kahilipara non-K village. So I do not find any reason why the defendant side will be prejudiced and how they will be prejudiced if I came to know that my village is something different. That number 3, it would be not only the Kahilipara non-K village, it should be number 3. After cross-examination.
No, when you came to know.
After cross-examination of the official witness. Because what happened, your lordship, is already seen in my sale deed, there is written number 1 Kahilipara non-K village. That time it was not surveyed. And there are 2 annexures. Annexure 3, page.
No. You have mentioned the schedule of your land. To be as per sale deed, land is situated in Kahilipara non-K village. Then your case is that later on it was bifurcated into 3 parts, 1, 2, and 3. And now the land falls within number 3 non-K village.
Yes.
When did you came to know about these facts?
Of the official witnesses.
Have you mentioned the same in your petition?
Clearly mentioned, but we have stated page 241. Page 241, paragraph 5, we have stated that with the passage of time, more particularly after the settlement, it was before non-K, prior to settlement. After settlement, Kahilipara now was further divided into 3 parts.
No, his main objection is that while allowing the amendment,
Yes.
the court did not take care of the proviso to Order 6, Rule 17, that there was due diligence.
And
how will you address that?
My respectful submission is that they have filed their written objection to my application. There also, there is no whisper of any due diligence. There is no whisper. That is there. Apart from that, Your Lordship, I just want to put, and their schedule in the counterclaim is no way similar to the schedule which I have now been corporate now, not now in the plaint itself. Just I wanted to insert a number 3. The village is number 3. And as per their schedule, what they are claiming, it's non-K village. So they should be happy that their scheduled property is something different.
No,
And they will get the opportunity to cross-examine.
yes, that is okay. But how will you overcome the embargo in proviso? law?
That is there, but first of all, they have not stated in their objection
Okay. Where is that?
anything. Page 256 onwards, they have not.
Suppose they have not stated
That
anything.
is there. But
Sta-
the proper adjudication of Your Lordship has the power to accept this amendment, which the learned trial court has given, only by inserting the number 3 of the bill before the prior to the name of the village. In this connection, I just want to hand over Your Lordship's judgment recently passed on 25th of May 2026.
Case number to Pogana. I thought, no, case number to
CRPA IO 412,
Which
paragraph 25.
Yes,
412,
412
23.
of 23. Mobile might. Anwar. Let it out. Paragraph 123.
Paragraph 25, my lord. Here the amendment was rejected. But Your Lordship has allowed the amendment by holding that for proper adjudication.
anything else?
And for multiplicity of, avoiding multiplicity of proceedings, my lord. Then Lordship, one judgment of 2019 15 SCC. There is a mistake, I admit, there is a mistake because we came to know it is the submission from the petitioner side also. After we came to know that there is some discrepancy regarding the number of the village, not the name, only the number of the
No,
village.
mistake is admitted.
Yes,
The
mistake is admitted.
mistake is in not pointing out the mistake. Mistake is in not mentioning in your amendment petition that why there was
Very correct. That I
that
agree.
ought to have
That-
been clearly indicated
That in the petition, it ought to have been mentioned.
that when you came to know about this.
Exactly. But here in 2019 15 SCC 628 paragraph 8, their memo of parties were not mentioned properly. The Supreme Court has said such inadvertent mistake cannot be refused to be corrected when the mistake is apparent from the reading of the plain. The rules of procedures are handmaid of justice and cannot defeat the substantive rights of the parties. It is well settled that the amendment in the pleadings cannot be refused merely because some mistake, negligence, inadvertence, or even infraction of the rules of procedure. The court always gives leave to amend the pleadings, even if a party is negligent or careless, as the power to grant amendment of the pleadings is intended to serve the ends of justice and not governed by any such narrow or technical limitations. I'm referring to paragraph 8 of 2019 15 SCC.
Okay.
Now that there are some other, I'm not, Your Lordship, the lordship is aware, I admit, they are.
You give the judgment which you are relying,
I have
not
I've given all the judgments I am relying on. In
heard.
2001 to HCC, I'm relying paragraph 5 and 6. Two thousand one to HCC 472.
Did not realize.
I'm relying on para 4 and 5.
No, you mark.
I'll mark it. I'll mark.
Okay.
Because it will be difficult to read out all the judgments and take the time.
My lord, in this time, I like to rely, my lord.
Moreover, just last submission, may I just make one thing. The issues I have given, there is no dispute regarding the suit land. Because these are completely different. Both the parties are claiming, your lordship has seen the report of the Lat Mandal. He says he is occupying some other land in the non-cape village. Now, no prejudice will be suffered by the defendant side. If I give number 3, that will be easier for adjudication of the dispute. Then why the defendant is vehemently objecting this amendment application? Because that will be easier for him also to establish his case. If it is totally different two plots, if I give number 3 Kahilipara village, then it will become a distinctive and separate plot of land. What they have claimed in their counter claim.
If it is so, my lord, let them strike off my name from the titles. Then let them do, let them take, let them 1, 2, 3, whatsoever.
Yes.
One more thing, my lord, lordship will see page 26 for a second, my lord. All the documents is obtained either 2015, 2008, 2017, man. Whereas there cannot be any due diligence, man.
Page number?
Page number 26 is the type copy, my lord. They filed a suit for a list of documents. That is the type copy, vernacular is the 27. And they have marked, my lord, date also, my lord. Some document 85, 08, 16, 17, 09, 15, 16, all they obtained, my lord. Trace map, including revenue, everything. That apart, my lord, in cross also, he said, my lord, that 120 page, my lord, that is not exhibited document. The moment, my lord, cross-examine was done, they want to cover up their lacuna, my lord. That too without any diligence.
Heard, Mr. J.I. Bhuya, J.I. Bhuya, the learned counsel for the petitioner. Also heard Mr. A. Bhoy, the learned counsel for the respondent. This application under Article 227 of the Constitution of India has been preferred by the petitioner Vishwaranjan Bora, impugning the order dated 21/2/2026, passed in Ms. J case number 248/2024, whereby in connection with title suit number 114/2017, whereby the petitioner, whereby the application filed by the respondent for amendment of plain by correcting the description of the village in which suit land falls was allowed belatedly. The facts relevant for consideration of the instant revision petition, in brief, are that the respondent herein has filed a title suit against the present petitioner seeking declaration of his right title and interest and any other relief
My lord, for recovery,
and for recovery of khas possession of the suit land
and injunction.
as well as for permanent injunction. The schedule of this suit land as described. No, the land as described in the schedule to the plain indicates that the suit land is a plot of land measuring 15.5 lechas out of 1 kotha, 11 lechas of land covered by dag number 514 within bracket new dag number 72 and 73 of KP Patta number 27 within bracket new KP Patta number 7 under Beltola Mauza, Gauhati in the district of Kamrup, Assam, situated at Kahilipara Non-K village under Mauja, Beltola. So the boundary of the suit land has been described as follows. On the eastern side, land and house of Sri Bhagwan Das. On the western side, land and house of Rajni Dekha. On the northern side, land of Shankar Chaudhary. Whereas, and on the southern side, land of Rabi Datta Lakar, the house and land of Rabi Datta Lakar. Stop. The present petitioner contested the suit by filing a written statement as well as a counterclaim. The trial court framed the issues and thereafter the evidence of plaintiff's witnesses started. Who is the official witness?
One is a senior assistant from DC office.
For you, for your side.
Yes,
On
sir.
your behalf. Stop.
And lot model.
Thereafter, after deposition of the no, after recording of evidence of the official witnesses, the respondent filed an application under Order 6, Rule 17 of the Code of Civil Procedure, read with Section 151 of the said code, seeking amendment of the description of the suit land in as much as that in as much as that in place of the village Kahilipara non-K village Kahilipara non-K, the description of the village is sought to be changed to number 3 Kahilipara Gaon. The present petitioner had filed an objection against the application for amendments filed by the respondent side. However, the trial court, by the order dated 21/2/2026, passed in Ms. J case number 248/2024, had allowed the said amendment of the plaint, and the said order has been impugned in this revision petition. Stop. Mr. J.I. Borbhuya, the learned counsel for the petitioner, submits that the trial court erred in allowing the amendment of the plaint after commencement of trial without indicating that in spite of due diligence on the part of without considering the embargo provided in the proviso to Rule 17 of Order 6, which prohibits such an amendment in absence of which prohibits such an amendment unless the court comes to a conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. He submits that the plaintiff, that is the present respondent, had filed the suit in the year 2017 and in the plaint as well as in the sale deed on which the plaintiff is relying in the title suit, the land, the suit land is shown to have been situated in Kahlipara Non-K village. He submits that though some of the documents which were annexed, this certificate is annexed along with plaint.
Well, during those days.
Annexed along with the plaint, namely the certificate issued by Revenue Authority. The suit land is shown to have been situated
The list of documents.
in number 1 Kahlipara village and
54.
in
Go to direct demand.
and this Jamabandi Annexure 75 at page 37. This Jamabandi is also annexed along with page 37.
Page 30. Draft cheater, madam.
Draft cheetah. This was annexed along with plain.
Yes. And another draft cheater, page 39. Two draft.
But this draft cheetah indicates the village name as
Pin number kind.
number 3. Then why have you?
As per sale lead, there is some confusion because as per sale lead, it's on take village.
Lamki लिखे last line.
If your lordship kindly see page 39.
Obtain police 70.
And in some other document, in some other documents, namely the draft Sitha, which were also annexed along with the plain, the suit land is shown to be situated in number 3 Kahilipara,
Sometimes 3, sometimes 1.
non-K village.
I apologize, my lord. Just page 39 is another draft data, which where only Kahilipara non-K is mentioned. Same that number, there's but 2 partners. That is why the confusion arose.
Dark number defines 27, 4. Dark number different in both 2 documents.
14.
However, he submits that it is only after examination of the official witness, namely, who is that official witness?
Page 12.
And at page
Page
165,
165, 166.
67. 165 and 167.
65 is the senior assistant and another one is the lot mandal.
Namely, officials from revenue departments. Who deposed that the respondent's name is not there in the draft Shita in respect of number 1 village Kahilipara and no, where he indicate that which portion?
My lord, page 166, recross examination.
Yes.
Exhibit 3 is related to number 3 number village Kahilipara non-K.
What is exhibit 3?
That is annexure 3, draft data, first draft data, page 37.
In exhibit 3, your name appears.
Yes, it appears. But in
Yeah,
there
he
is-
lists last line.
No, it doesn't appear, man. Srimati, Alpana,
Here in
Narendra
the
Bhattacharya
middle,
and Purna Bhattacharya.
Horiday দখল ভুট্টে 1 নম্বর পাট্টাদার আনটু পাট্টাদার স্থলত শ্রী নিখিল চন্দ্র ঘোষ পিতা পিয়ালি চরণ ঘোষ।
Where is exhibit 3?
Page 37, In the circle, it has been mentioned.
Equal to.
Yes.
एक नंग पट्टा नंबर तो पट्टा नंबर डिफरेंट है पट्टा नंबर क्यों
And that the exhibit 3 draft Sita, where the name of the respondent appears, is related to number 3 Kahilepara non-K village. The respondent approached the court seeking amendment of schedule to his plan by incorporating number 3 non-K village in place of number 3 Kahilipara non-K village in place of Kahilipara non-K village. Learned counsel for the petitioner has submitted that that the amendment is sought for by the respondent only to cover up the lacuna after cross-examination of after the different facts are revealed during cross-examination of the official witnesses. He submits that once the trial has commenced, amendment may not be granted, amendment may not be allowed unless courts come to a conclusion that in spite of due diligence, the party could not have raised the matter before the commencement of trial. And in the instant case, no such due diligence has been pleaded by the respondent in his amendment application, in his petition seeking amendment. Stop. He therefore submits that the trial court erred in allowing the amendment. As such, the impugned order is liable to be set aside. In support of his submission, he has cited following rulings. These 1 to 5. Black flag, green flag. On the other hand, Mr. A. Dhar, the learned counsel for the respondent, has fairly submitted that the description of the suit land, of the village in which suit land is situated, was wrongly mentioned by the respondent / plaintiff in the schedule to his plain. He submits that the only error is of not mentioning number 3 non-K village. Number 3 non-K village, non-K Kahilipara village. As the petitioner has as the respondent has only mentioned the name of the village as Non-Ke Kailipara village, as in some of the land documents, the description of land, description of the village in which the disputed land, in which the suit land is situated, has been given as Kailipara Non-Ke village. He fairly submits that the fact that the land in respect of which the petitioner's name, the respondent's name has been has been incorporated in draft Chita is covered, he falls within number 3 Non-Ke Kailipara village.
As well as only non-K village, page two dark numbers are there. Page 39.
Came to be,
Two portal numbers.
there are two suit. Nay. What is this?
Now the Lordship will see the schedule is new dark number 72 and 73. And this Chita, page 37 pertains to dark number 73 and 39 page pertains to page dark number 72. That is why the confusion arose. Here, page 39 only Kailipara Non-Ke mentioned, and page 37 3 number Kailipara Non-Ke is mentioned in the draft paper.
I have to go through. Dot. Order reserved. I'll go through the records. And
Only one more thing, my lord. That's another 7-8 is the 8-7 is the date. This 8-7.
No, today I will pass the
My
order
lord.
in
And
chambers
apart from
after
that, my
going
lord,
through the files.
apart from that, my lord, I like to apprise your lordship, my lord. The Lord Mandal said, my lord, his name is mutated in the village number 1. That we see.
I'll deliver the orders in chamber today.
Lordship.
It is little bit complicated.
No, records have to be gone through
My
properly.
lord, it will settle the law, my lord.
Law is settled.
No, my lord, diligence. Diligence part, my lord.
You have yourself given numbers of rulings.
Yes, my lord.
I have
Okay.
given the Lordship's last judgment.
Okay, wait for some time.
Lordship,
Obliged.
obliged. my lord.
Your Lordship, this is an application under Article 227. The petitioners are defendants in OA number 270/23 in DRT proceeding, Your Lordship, which is pending for disposal. And the petitioners had filed an IA under Order 11, Rule 14 and 15 of CPC for production of certain documents, Your Lordship. And by the impugn order, that IA was dismissed by stating that those documents are already part of OA, and also that the petitioners was not present during the production of the original document, Your Lordship. That is why admission denial at that particular date, the learned senior counsel was not available and he was not able to be present, Your Lordship. So hence the IA was dismissed. So we filed this CRP, Your Lordship. Actually, there are some various anomalies in the OA, which we have highlighted already in the WS. And there are various transactions, like certain transactions which are not linked to the original debt, Your Lordship. So without the protection of those documents, it will be very difficult.
A similar case was
Yes, Your
filed.
Lordship, it is a related case, actually, same family member. Your Lordship had passed last week, Your Lord. This is the son actually of the other petitioner, the Muslim Majul.
In the same case or a different case?
It's a different case, but the same family, Your Lordship. And this is a different debt. So herein the petitioner is Atwar Rahman. Atwar Rahman is the son of Muslim Ali, Your Lordship. Muslim Ali in the Lordship had passed the order, Your Lordship. So similar, similar order has been passed, Your Lordship. The operative part of this order is last is, Your Lordship, 203 of the CRP, Your Lordship. Page 203, Your Lordship, the impugn order. Lordship, second giving the reasoning, Your Lordship.
Read the second para. It is.
May I read, Your Lordship?
Yes, second para only.
Yes. It is evident from the record that the applicant bank had already annexed the documents with the original application, which are relevant for the adjudication of the case. As per order of this tribunal, the applicant bank had produced the original documents, but the defendants has not verified the same since they are not appeared on a particular date. The applicant bank had acted as per terms and conditions of the documents executed by the defendants with the applicant bank. Since the allegations of this IA are similar to the allegations made in the written statement, so it will be decided at the final stage of hearing. Therefore, there is no need to produce such documents for the execution of the case in proper way. In view of the above discussion, I do not find any merit in IA number 536 or 24. Hence, IA is dismissed and disposed of. And Lordship, now the case is fixed for final hearing. That is on 27th of July, Your Lordship. So without these documents, it will be very difficult for us to present our case, Your Lordship.
Heard. Mr. What is your name?
J. Das.
Heard, Mr. J. Das, the learned counsel for the petitioners. This petition under Article 227 of the Constitution of India has been filed by the petitioners impugning the order dated 3/2/2026 passed by the Debt Recovery Tribunal, Gauhati, in IA number 536/2024 in original application number 275/2023, whereby the application filed by the present petitioners under Order 11, Rule 14 and 15 for production of original document by the bank bank is the respondent. Bank within bracket respondent number 1 was rejected. The learned counsel for the petitioner has submitted that though as per direction of the DRT, the bank had produced the original documents. However, on the date when the documents were produced, due to ill health, this is your reason?
Yes, Lord.
Same reason?
Yes, Lord. Senior counsel.
Due to ill health of the engaged counsel for the petitioners, same could not be inspected. Stop. However, the DRT by the impugn order has observed that there is no need to produce the original documents and thereby depriving the petitioners the right to inspect the documents as provided by law. Stop. Let the notice be issued to respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post, as well as by usual mode within 7 days of the date of this order, returnable on.
Lordship, and till that then further stays maybe stay, your lordship. Next date is 27th of July, your lordship.
14th of August. In the meanwhile, considering the submissions made by learned counsel for the petitioners, the further proceeding of original application number
275 of 23, your lordship.
275 of 2023, pending before the Debts Recovery Tribunal, Gauhati, shall remain stayed till next returnable day. List accordingly.
Highly oblige, your lordship. May I please, lordship? Lordship, the facts connected to the instant revision petition is such that, my lord, against the ex parte decree, my lord, we have filed an application on the order 9 rule 13, and that was, my lord, not allowed, and based on that, my lord, we have filed an appeal. Now, while we have filed appeal, my lord, the appellate court remanded back the matter to the trial court for fresh consideration. Now, accordingly, my
Fresh consideration of
lord, my application on the order 9
Order
13
9
along with limitation petition, my lord. Now, while my lord,
no, your delay was not condoned or what?
the both were dealt with, therefore fresh consideration was my lord, directed to be considered. Now, my lord, what happened during the course of proceeding? That matter was taken up by the trial court, but what happened inadvertently on particular date, we could not appear. That is 19/2/2024, and on that day, my lord, there is a 19/2/2024, first date. Thereafter, my lord, on 20, the matter was again posted. Sorry, my lord, the matter was posted on 20/2/2024, and my lord, afterward, my lord, what happened, my lord? On next date, my lord, another date was fixed, and based on that, my lord, my absence, my lord, the petition was rejected.
When?
My lord, on 20/2/2024. Earlier matter was on 19, my lord. That order itself reflect, my lord. The order contained in, my lord, page 54. Now, lordship, the two issues are there, my lord. In this instant order, I am not going to dispute any facts, my lord, because the both sides have their own submission, my lord, about the disputed fact. I am not on that. I am absolutely on legal point, my lord. My lord, what happened in this case?
Which page is the?
My lord, the impugn order that, my lord, which was, my lord, earlier rejected, that is page 51, my lord.
50?
51, my lord.
51.
22/12/24.
Yes. Due to your default.
54, my lord, sorry, 54.
54.
Yes, my lord. 22/12/24.
There is no page number 54.
My lord, sorry, my lord.
After 51, there is page number 55.
My lord, prior to that 55, my lord, 51, pagination is, my lord. I admit, my lord, apology for that. Order dated 22/12/24.
No apology. You correct the pagination.
My lord, it should be 50, but lordship, kindly for a moment, my lord.
You correct it. 4 pages are missing.
My lord, kindly see 52, 53. Lordship, just look for a moment.
There is no 52, 53.
My lord, just prior to that, my lord, kindly have a look. The petition part in on 51, 52 verification.
51 is an order. We will be unable.
No, lordship, may kindly take 51 as a part of order. For a moment, my lord. Petitioner is absent without any steps.
No, unless the brief which you are holding and the records tallies. How
My lord,
will
then
I?
lordship, no problem.
You rectify it, we'll take
Yes.
it tomorrow. Let
No
him
problem.
rectify.
My lord.
They rectified copy to me also.
Absolutely, absolutely.
In your copy also it is.
Yes.
My lord, no problem, my lord. We'll rectify and my lord sub the copy to the other side. Lordship, may kindly post this matter to court.
Heard Mr. S. Samaria, learned counsel for the petitioner. Also heard Mr. A. Sattar, learned, your caveator. learned counsel for the respondent. It appears that it appears from record that either there is some error in paginating the pages of this revision petition or some pages are missing. When this matter was brought to the notice of learned counsel for the petitioner, he sought some time to rectify the same and prayed for listing the matter when
Tomorrow, my lord,
Tomorrow.
we have interim prayer, my lord.
again. Let this matter be listed tomorrow. In the meanwhile, the rectification of the pagination shall be done by the learned counsel for the petitioner, both in the court's copy as well as in the copy furnished to the learned counsel for the respondent.
5 and
This-
6 analogous matter, my lord. 5 and 6 analogous matter. Both may be taken together.
This matter again on 24th, along with CRPIO number 275/2026.
Much deep level.
So item 6 of Likibo.
My lord,
List this matter along with CRPIO number 274 tomorrow. That is on 24th June. This CRPIO is dismissed on withdrawal with liberty sought for granted.
Master.
May please, your lord. My lord, few of the order passed in the last occasion, Lord, I have filed addition affidavit, my lord. Bringing on record the decree which has been passed by the learned tribunal. Lord, you will find page 76 of my additional affidavit.
Okay, what is the method here?
According to me, I have taken the certified copy of the judgment and decree, and I have enclosed the judgment and decree by way of additional affidavit.
Okay.
That has been
Now,
before-
what you are impugning in this?
But in last occasion, instruction was proper as regards to whether there is any description in the suite property in the decree, madam.
Yes.
On perusal of the decree, there is no description of the suite property, madam. There is no. Last you may take note of page 76. Additional.
No, what is your case? Please refresh.
Yes, yes, yes. What if, my lord, judgment and decree was passed, and accordingly, basing on the judgment and decree, my lord, the execution proceeding has been initiated by the present respondent, my lord. In the meantime, my lord, I have preferred an appeal, and that was dismissed, and second appeal is, my lord, I have preferred. That is, my lord, before this honorable court, for rectification of some correction, my lord. What happened? During the pendency of the said execution proceeding, my lord, I have filed a petition under section 47, my lord. Because of the fact that so far the boundary given by the, my lord, the decree holder, my lord, it cannot be, my lord, identifiable, and that has to be identified before, my lord, making execution. Because, my lord, I am, my lord, residing in a, my lord, plot of land which is not, my lord, covered by the sweet land, my lord. That is no decree was there, my lord. But despite that, my lord, the respondent has insisted my lord, officers, my lord, to evict me, my lord. Moreover, my lord, so for the other convention is there, my lord. Lordship may take note of my application at page 54. Thank you. Sorry, my lord. Page 58. This application has arisen out of the notice issued to the bailiff Because, my lord, in the earlier occasion, my lord, the Learned Executing Court has directed the bailiff to execute the decree in relation to the 5 lessors of land, over which, my lord, no decree was passed. Because, my lord, the originally suit was for right to declaration of right to interest over 2.5 lesser, my lord. But the decree was going to be executed over 5 lessors of land. However, my lord, that part has been now rectified, my lord. Now, my lord, what happened? My this application has been rejected by the Learned Executing Court by the impugn order, which is at page, my lord, 67, my lord.
Yes.
Now, my lord, the Learned Executing Court below has observed that the before execution, my lord, that will be, my lord, identified. My lord, what happened, my lord? That since the decree is, my lord, silent about the description of the suit property, which is, my lord, required to be, my lord, filled up in view of Order 20 Rule 9, my lord. My lord, in absence thereof, unless and until the decree is corrected, my lord, no execution can be taken place of, my lord. Because, my lord, I am so far that part is concerned. If you like note the Order 20 Rule 9, my lord. If the decree is in relation to, my lord, recovery of immovable property, my lord, then Rule 9 will cover, my lord. Order 20 Rule 9, my lord. May I read it also? Decree for recovery of immovable property, where the subject matter of the suit is immovable property, the decree shall contain a description of such property sufficient to identify the same, and where such property can be identified by boundaries or by numbers in a record of settlement or survey, the decree shall specify such boundaries or numbers. This part is missing in the decree, my lord. So before, my lord, execution, that has to be, my lord, ascertained as to the identity of the suit land, my lord. So accordingly, my submission to lordship, since the decree has been going to be executed without having the, my lord, specification as regards to the suit land, unless and until it is corrected, my lord, that cannot be executed, my lord.
Where is the decree?
Decree is at, my lord, page 76 of my additional affidavit, my lord. Page 77 reflects the, my lord, order, my lord. Now the next page, my lord, cost. No description of suit property is there, my lord.
Heard Mr. N.K. Sharma, the learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner, namely Shri Arun Rabha, impugning the order dated 11/5/2026 passed by the Executing Court of Learned Civil Judge Junior Division of Dalguri, whereby the application filed by the present petitioner under section 47 of the Code of Civil Procedure in title execution case number 1/2023 was rejected by the by the executing court. These 5 lectures was rectified.
My lord, so far the bailiff's previous notice was that has been rectified, my lord. That's in place of, my lord, 5 lessons of land, now it has been put 2.5 lessons, my lord. And boundary has also been, my lord, rectified.
Where?
In the subsequent bailiff's notice, my lord. Notice to the bailiff, my lord, for execution. My lord, I have annexed the one of bailiff notice, which is at lordship may page 65, my lord. Page 65. My lord, page 66 is the, my lord, schedule and which is going to be executed. There is, my lord, the 5 quarters of land has been going to be executed, having the different boundaries, my lord. Now I have been informed, my lord, that that part has been, my lord, rectified.
Learned counsel for the petitioner has submitted that though in the decree prepared in title suit number 11/2015, after decreeing of the suit in favor of the respondent, no description of the decretal land has been given, which is a mandatory requirement under Order 20, Rule
9, madam.
Rule 9
Rule
of the
9.
Code of Civil Procedure. However, in the writ issued by the executing court, the suit land has been mentioned. He submits that unless the decree incorporates the decretal land in terms of Order 20, Rule 9 of the CPC, no writ can be issued by the executing court. As such, he prays for stay of proceedings of execution case, title execution case number 1/2023. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 12th of August. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, further proceedings of title execution case number 1/2023 pending before the Court of Learned Civil Judge Junior Division, Dalguri, shall remain stayed till next returnable date. List accordingly.
Highly obliged.
Met please, Lordship.
The size of your petition.
Otherwise, issue is very simple. I prayed for stay of the impugned order passed under Section 9 of the Arbitration Act matter before the learned judge. The stay prayer was rejected. Main appeal is still pending. So I have challenged the order whereby the prayer made by me for stay of the impugned order was rejected.
What was impugned?
My lord,
What was the impugned order?
order under Section 9 of the Arbitration and Conciliation Act, whereby
Stay was granted.
Stay injunction was granted. Section 9 provides for certain kinds of orders that can be passed between the parties who are party to an agreement where there is an arbitration clause. Before or after invocation of the arbitration clause, my lord, the
Yes.
parties may approach under Section 9. So
So-
they have approached, obtained an order. Against that, I preferred an appeal, my lord. In the appeal, my lord, I prayed for a stay of the operation of the order. That was rejected. Against that, I have come before lordship. The main appeal is still pending before the learned judge.
Similar cases were filed
Yes.
between the
It has
parties
in fact come up before your lordship.
on more than one occasion.
Yes, more than one. And different courts also. Which method?
It is by the same party,
Yes, yes, it's the same dispute, my lord.
same dispute. Why it has come again?
My lord, you will recall, first of all, the Section 9 order was passed in my favor. They wrote repeated representations to the bank to freeze the account. Thereafter, I approached under Section 9, the court ordered defreezing of the accounts. That was an ad interim order. Against that ad interim order, this court was approached on numerous occasions. And eventually now the Section 9 order has been finally decided. And it has been, the interim order has been made absolute. Against that, my lord, will recollect an appeal was preferred here. Your lordship said that it should go to the commercial appellate division. Thereafter, it went to the commercial appellate division, my lord, and they pressed for a stay of the interim order under Section 9.
That was rejected.
That appellate court says that this the merits have to be gone in.
So this is against the commercial appellate division's order.
Order declining a stay only.
Okay.
Now, my lord, will issue notice at the juncture because if your lordship stays the Section 9 order.
I am not praying for a stay, my lord. What I am, my lord, I have got a lordship may kindly hear me. What has happened, my lord? Initially I was not here, my lord. I am a party, I am a member of all these concerns who are under the Protect group, my lord. I have got a majority stake in all these firms. Now, by virtue of the order passed under Section 9, I am practically out. They have approached under Section 9 saying that I have written to the bank to freeze the accounts.
Yes.
Along with that, they have also made a prayer that I should be restrained from interfering with the affairs of the company.
Yes.
Now, my lord, before they approach the learned civil judge under Section 9, I raised certain issues that, see, you are misusing the fund of the company. The respondent number 1, who was the applicant in the Section 9 petition, my lord, he is operating and running a competitor firm, and the employees of Protect Group are being diverted where the remuneration is being paid by this company and their services are utilized there. Ambika Group. Then they are diverting fund, misusing their position. All this I have raised, my lord, so far as the bank is concerned, my lord, by after I failed to get any relief, my lord, I ultimately had to approach the bank to say that kindly freeze the account, otherwise nothing is happening. Bank had frozen one particular account. Immediately thereafter, they have approached this the Section 9, they filed Section 9 application, my lord. If your lordship kindly goes to Section 9 application, I'll just show, my lord.
page 101 of volume 1, my lord. Now, my lord, there is a blanket order whereby I am practically out of the entire Protect Group companies. So far as freezing problem was there, my lord, that I have conceded that I will not take any steps. And the conduct of the bank, I'll show, my lord, how they are in collusion with the respondents.
Where is the impugn order?
Well, impugn order, your lords will find at page, this present impugn order is page 742, my lord, in the volume 2. That will be in volume 2, my lord.
It is very difficult to handle.
My lord, my lord. While passing the interim order, the learned district judge has practically decided all the issues in the impugn order itself, in the interim order itself. That itself is an illegality, my lord. Page 759 is the operative part of the order. I have got a very limited prayer, my lord, before your lordship.
What is your prayer?
Prayer is that my lord, that blanket order that I should not interfere with the affairs of the bank, they are taking advantage of it and they are not allowing me to participate in the business. Where from do you get this power?
759.
My lord,
Which
759. 759 para 19 onwards. Perusal of the impugn order reflects that the order passed by the learned trial court in the arbitration case was interim in nature, and on careful perusal of the impugn order reflects that the said order, if not stayed, will not have any serious civil consequence. After taking into consideration all the above facts, this court is of the view that the plea taken by the petitioner for stay of the operation of the impugn order relates to the merit of the case, and such plea can be decided only during the hearing of the concerned appeal. After taking into consideration all the above facts, this court is of the considered view that it is not a fit case to grant stay regarding operation of the impugn order dated 7/2/2026 passed by the learned civil judge in arbitration number 1, Kamrup, in arbitration case number so. Accordingly, this court is not inclined to grant stay.
Where is the 17/2/2026 order?
Yes. It is 494. 494, my lord. Second. Page 7. Issue, right? Client will talk to the vehicles.
Where is the operative part?
Page 592. 592, my lord. Particular 592, my lord. The second paragraph. Hence, para 25. Hence, I am of the considered opinion that all the three golden principles are in favor of the petitioner at this stage. Hence, the instant petition is disposed of with the following directions till constitution of the arbitral tribunal. An interim injunction restraining the opposite party number 2 not to freeze the current account number so and so of the petition number 1 firm held in Indus Bank, Ganeshguri branch, and honor all debit payment requests made concerning transactions of the said bank account prior to date of freezing till constitution of arbitral tribunal. And this part is more offensive. An interim injunction restraining the opposite party number 1 firm from interfering with day-to-day affairs of the petitioner number 1 firm and its sister firms concerns, he is further restrained from taking any action from closing, freezing of the transactions in the current bank account petition number 1 firm number so and from taking any action from freezing the accounts of any sister companies, subsidiaries, or the parent companies, firms of the petitioner till constitution of the arbitral tribunal. My lord, the lordship may kindly have a look at the page 60 for a moment, ma'am. Yeah. Page 60 in volume 1.
60.
Page 60, ma'am. Page 60. Yeah.
Yes.
My lord, this is the partnership deed. I'm drawing your lordship.
Page 60.
60, my lord. 60.
Yes.
This is the partnership deed of Pride Realty. Section 90. My lord, page 62 are the partners of the firm.
Yes.
My lord, number 1 is Manoj Kumar Jalan. Number 2 is Sri Lokesh Anand Singhal, who is the petitioner before your lordship. And number 3 is Associated India Private Limited. And this deed was, my lord, lordship may kindly have a look at the profit sharing ratio at page 64.
Yes.
Paragraph 7, my lord, the net profit and loss of the partnership business shall be divided between the parties hereto above in the following ratio. Applicant in the section 9 petition 40%, petitioner before lordship who was the respondent there, my lord, is 40%, and Associated India Private Limited is 20%. Now, this partnership deed was subsequently reconstituted, which your lordship will find at page 68.
Yes.
Now, when it was reconstituted on 12th of April 2023, lordship will find at page 70 who are the present partners, my lord.
Two more partners were
Yes, my lord.
inducted.
In fact, 3 more.
3 more. Yes.
3 more. And so far as number 3 is concerned, that company has retired. So presently there are 5. Lordship will find number 1 is respondent number 1 before your lordship, Manoj Kumar Janan.
Yes.
Number 2 is the petitioner. And number 3, my lord, since it has retired, so it is no longer existing. Number 4 is the wife of partner number 1, M.K. Jalan, my lord. Number 5 is the brother of the petitioner. And number 6 is the mother of the petitioner. Petitioner, who is number 2 here, my lord, in this partnership deed, and 6, who is the mother, both of them are petitioners before your lordship. Both of them are agreed by the impugn order. Now, I am pointing out this reconstituted agreement also for the purpose of giving the profit and loss sharing ratio at page 73, my lord.
Yes.
Lordship will find, so far as respondent number 1 and 2 are concerned, they have got 10%, 10%, altogether 20%. So far as petitioner is concerned, petitioner number 1 and 2 before Lordship, they have got serial number 3 and 5, my lord, 25% and 20%, 45%. And also number 6, this is Protect Realtors Private Limited, 5%. So it comes to 50%. Petitioners before your lordship are the stakeholders of 50% of this company. 55 altogether, madam. I am the majority shareholder of the firm. Now there is a order passed by the learned civil judge, my lord, whereby I am prevented by an order that do not interfere. My lord, do not interfere is an expression normally to be understood in the sense that I am going to interfere in the affairs of somebody. But if you take advantage of this order so as to deprive me of my rights to participate in the day-to-day affairs of the business, then that order cannot be allowed to prevail, my lord. That is my submission before lordship. I am not saying that entire order of section 9 should be stayed. So far as freezing the accounts is from problem concerned, my lord, that problem they had, I am saying that I am not going to freeze the accounts. That was a different stage. And why I did that, I will show from the 2 and 3 notices, my lord, just now before your lordship.
So what are you praying today?
Madam, I am only praying that that part of the order which says that do not interfere with the day-to-day affairs of the business, that should be modified, that should not be kept for the time being. Because that is not going to harm them in any way. They are agreed by my action in taking steps before the bank to freeze the accounts. They have made a submission before the learned trial court, my lord, that no, if this kind of order is, if this order remains or if it is allowed to take such steps, because they are in real estate business, my lord, the intending purchasers who have made advance payment for purchasing flats, they will suffer. So no, I'm not going to do that. But by taking advantage, because what is happening is, my lord, there are certain illegalities which I have pointed out by 1 or 2 notices earlier, and then I had to write to the bank that please freeze the account because they are not listening to me. In between, there was a settlement also, mediated settlement. That settlement also they do not want to, my lord, adhere to.
Yes, Mr. Deka, you are appearing for whom?
1 and 2.
Only 1 and 2.
Lord, will
So notice,
at this juncture, why I say this is because of this, my lord. First of all, there's a long checkered history, my lord. Appeal is already pending before the appellate court, my lord.
Yes.
Now the appellate court says that whatever has been urged in the stay application cannot be decided before the merits of the appeal. So the appeal has to be heard finally before any interim stay is granted, my lord. And quite rightly so, my lord. There's so many aspects to this. Because ultimately, their conduct throughout has been that they've filed repeated applications for freezing. Your lordship will recollect, even while the interim order was operating, my lord, they again coerced the bank to freeze it, for which we had to move a contempt. And again, a subsequent order was passed, again, defreezing during pendency, my lord. Now, this order, eventually, if your lordship stays it, my lord, it tantamounts to not just allowing the civil revision, my lord, but also allowing the appeal before the commercial appellate division. Because that is the moot issue, whether he should be allowed to interfere and freeze the accounts or not. So the commercial court has today, the order as it stands says that you cannot do so. Now against that, they've already moved an appeal, which is still pending consideration. In fact, it is fixed tomorrow. Now in the stay application.
Tomorrow, the appeal is fixed. At what stage?
For necessary order, because last date perhaps it was declared a holiday.
My lord, appeal hearing will take some time. In the meantime, should I be prevented from taking part in the day-to-day affair of the business? That is the sole issue to be considered.
Exactly.
That has got nothing to do with the merit of the case. And what was their grievance? My lord, their grievance was that I was writing to the bank to freeze the accounts.
But that matter is pending before the appellate court.
My lord, no. My lordship will kindly see. What was the order passed? That do not take steps before the bank to freeze the accounts. I am today saying that I am not intending to write any letter to the bank. Now, next is they are enjoying the order that do not interfere with the day-to-day affair. Why this blanket order, my lord? I have just now shown, my lord, what is my stake. I am a majority shareholder. By virtue of this, I am out of the business.
But you have preferred an appeal under
True.
37.
My lord, during the pendency of the appeal, whether I can be prevented from participating in my business, I am 50%, 55% shareholder. And during the pendency of the appeal, I will be out of the, my lord.
That grievance you can raise before the
I have
appellate.
raised, that is why I raised before the learned court below, district judge, that kindly modify that order so that I can participate. Well, how can they prevent me from asking for an order that I should be given the liberty to participate in terms of my stake in all the partnership farm and other sister concerns. Now the order is so blanket in nature, my lord, that not only this farm, Pride Realty, in respect of which the whole section 9 petition was filed, in respect of only one farm, there is Pride Realty. Now, in the prayer portion, they have given that kindly pass this blanket order in respect of all the sister concerns. Now, all the sister concerns are within the purview of this order. And I am out of the business. I am roaming in the street. Can that be allowed, my lord?
Yes, Mr. Dekar,
Yes.
regarding second.
Examine, because I can show, my lord, there's so many aspects. For example, my lord, just to point one, page 73, they have referred to kind of suggest that they are the majority shareholders. My lord. Now, this deed of reconstitution, they want to, my lord, estoppel will operate from all angles. How? I'll show you. I'll show your lordship. My lord. Page 73, they rely on that particular profit sharing clause to suggest that they are majority shareholders. What is their stand before the trial court, my lord? At page 157, they say that this particular deed is fraudulent. Now, today they are relying on this deed to suggest that they are majority shareholders. That's number one. My lord. Number two, my lord, this CRP itself is not maintainable because the one of the partners' name has been struck off. My lord, what had happened here, my lord? They are
This CRP.
in this CRP. Because Associated India Private Limited, represented by the family elder Indumati Singhal, was a party there. Now, what they did was, if your lordship for a moment, as page 726.
No. First, that this second deed of partnership.
Yes.
They're pleased that this is fraudulent. Where is that plea?
Page 157.
I'll clarify that, man.
And I will show even the second direction to restraining them from interfering is totally justified in the given facts and circumstances.
Yes.
Paragraph 7, my lord, at page 157. That the petitioner number 2. Now, all throughout, a projection is made as if it's a dispute between the two families, my lord. That is not even the case, my lord. Half of besides the petitioners, my lord, both the families are together, my lord. I'll show from the records. Page 157 for a moment, if your lordship has.
Yes. Yes.
That the petitioner number 2, has your lordship found it?
Yes.
These are just my preliminary objections regarding the very tenability of the claim, my lord.
Please read.
That the petitioner in petitioner number 2, in collusion with the petitioner number 4, in the most illegal manner and without any consent and approval, and behind the back of the OP number 1 executed a registered deed of reconstitution by deed number so and so, giving effective from 1/4/23 amongst the petitioner number 2, 3, 4, 5, and 6, and OP number 1 and the pro forma opposite party number 4, both represented by the petitioner number 4 and pro forma opposite party number 5. In the said deed, the pro forma opposite number 5, who is one of the partners by deed of partnership of pride realty dated so and so, shown as retiring partner in contravention of clause 18 of the said deed of partnership dated 22/11/2021. Inasmuch as pro forma opposite party number 4 did not retire from the partnership firm after giving 3 months calendar notice in writing, nor the said partner retired with the consent of the remaining directors, and therefore the formality of such mandatory notice cannot be waived. Further, petitioner number 4 cannot represent the pro forma opposite party number 4 in absence of any board resolution. The petitioner also cannot act as attorney on behalf of the OP number 1 inasmuch as the event for which the said power of attorney was executed ceased to exist since March 2020. Furthermore, the petitioner number 4 never adhered to mandatory clause 11 of the said power of attorney at any point of time. Hence, the alleged deed of reconstitution dated 12/4/23 is nothing but a fraudulent and sham document. Now, if your lordship may come to that deed of reconstitution once again, my lord. Page 68. So this particular deed at page 68 is alleged to be fraudulent.
In their objection against 9 page.
In their application under 9. Now, my lord, if your lordship sees that
in their objection against
section 9, in their objection against section 9.
Okay.
Now, by this deed of reconstitution, first of all, there were just 3 partners in the initial deed of partnership. Those are serial number 1, 2, and 3.
Yes.
Now, 3 is shown to have been retired, so therefore they say it is fraudulent. Associated India is shown to have been retired, who was represented by Vivekanand Singhal, etc. It's shown to be fraudulent. It's claimed to be fraudulent. Now, by this very deed of reconstitution at serial number 6, your lordship finds Shilpi Anand Singh,
Mother of the present.
mother of the petitioner, who's the revision petitioner here. Now, your lordship will mark the contradiction.
Earlier, she was not.
She was not even a partner. Now, today, after having said that this deed is invalid, if this deed is invalid, Shilpi Anand Singhal is not a partner as per the original agreement, my lord. So, how is she even today filing? If they stick to their stand that this particular deed is fraudulent, then the very induction of the civil revision petitioner number 2 is bad. And then how do they calculate the profit share by including by the profit share given at clause 73 and claim that they are a majority shareholder? There's more to the story, my lord. They initially filed the application for vacation. Page 229. So, but for this particular deed, Shilpi Anand Singhal has no locus. But they have challenged this particular deed as fraudulent. If this deed is fraudulent, the civil revision petitioner number 2 cannot have a locus to approach this court. She's not even a partner then.
What is there in 229?
My lord?
229.
Yes. 229, my lord. This was an application filed with a similar prayer that is urged today in the original proceedings, my lord.
Yes.
Now, this application, your lordship will find
229 appears to be a written objection.
no, 229. My lord will refer to the page numbers on
There are
the
many
right.
page numbers.
Yes.
On the extreme right.
In the extreme right.
Yes. This was against the interim.
Ad interim order, they said that it should be modified and a similar prayer was made, I should be also allowed to operate the bank account.
Lordship, let me complete my part, I have not completed.
My lord, let notices be issued, my lord. This will require hearing.
My lord.
Otherwise, I would suggest that the appeal, since it is already pending, my lord, all of this has to be decided in the appeal, my lord.
My lord,
This cannot be
my submission is let the order passed by the learned first court, my lord, under section 9 remain so far as the direction or restraining me to take steps for freezing the accounts are concerned, by which they say they will be suffering. But the second part of the order, which says that do not interfere, should that order remain or not? That is the only question before your lordship, my lord. And my learned friend has shown that subsequent reconstitution I have challenged. Yes, I have challenged because on my behalf, I was present here. On my behalf, my brother signs and reconstitutes. That was the reason for which I objected. And assuming for the time being that I object, although I have not challenged this before any court of law, supposing tomorrow I challenge, then the original, supposing tomorrow I challenge that reconstitution.
You have already
challenged.
raised objection.
I have raised objections. Supposing, my lord, yes, if your lordship accepts that I have raised the objection and reconstitution should not be accepted, then the original one will remain. I want the original one to remain. I am a 40% stakeholder in the partnership according to the original agreement, 60%. Then my position becomes even better. My prayer becomes even more meritorious. By the argument that reconstitution was challenging, it is neither here nor there. If reconstitution goes, I will go by the original agreement. Original agreement, my position becomes better.
How you will? In original deed, you will be having 40% profit sharing.
60%. 40%.
40%
And 20, I will show, my lord, how it's on my side.
20, they will say on their side, I will say on my side. So even if I am 40, let us assume for the sake of argument, my lord, 40. Can I be prevented from participating in the affairs of the business only on the ground that appeal is pending? It is yet to be decided. That is not to be decided by the appellate court. Appellate court will decide whether any order under section 9 can be passed or not. But meanwhile, supposing 2 years, 3 years, this section 9 disposal takes place, and I'm out of the business, and I'm out of those decisions which will be taken in the meantime by the companies, can those decisions be reversed? This is an irreversible, my lord, damage.
The appellate
Because my only one submission, by modifying this order, in what way are they going to be affected, my lord? I am not saying that they should not be given their share of profit. I am not saying that they will not participate in the business to the extent they have got stake in the business. I am not praying for all these things. They have obtained a blanket order. What has happened, my lord? When I write to the bank, my lord, what the problem is in this case is, my lord, elsewhere. Lords, may I kindly have a look at this document, page 180.
Suppose this court grants stay now.
I'm not praying for stay, my lord.
Second part, stay.
Second part, yes. What happens, my lord?
Then
my lord,
the matter is already pending before the appellate court.
Matter is pending for what? For deciding whether section 9 order should remain or not.
Yes, section 9 order contains two parts.
Two parts.
Both parts.
Yes.
In respect of one part, if this court comes to a finding,
my lord,
will it not influence the appellate court?
My lord, that is what I'm saying. The second part which says that I should not interfere. If this second part is interpreted by the bank in such a way that he is Mr. So-and-so is the sole signatory, and I have got no role in the financial affairs of the business, can this be allowed to remain, my lord?
No. This is the question to be decided by the appellate court.
No, my lord, what has happened?
In section 37 application.
My lord, there is one difference. This, my lord, just have a look at page 85 more. I'll just point out, my lord. Page 85. There is a reason, my lord, why they want this order to remain.
No, it will not remain if it is not legally tenable. It will not remain forever.
Supposing they succeed in showing that they are entitled to an order under section 9.
Yes.
Can that order go to the extent of depriving me of my rights to participate in the business in any manner? They cannot. Because that will amount to.
Unless you are
that will amount
outside
to-
from partnership.
My lord, that will amount to ousting me from the entire business, whereas I am a partner in the business, having 40% stake.
Yes.
My lord, assuming for a moment that ultimately I fail in the appeal, what happens? I am out of the business. Now, partnership deed says I have got 40% stake by the first agreement. Can that order be passed by the appellate court in any way, my lord? Technically, it is aside. This is what is happening. Now, what happened, my lord? In between, when I raised all these issues, I issued two focus. Lordship will permit me to point out just two documents, my lord. First is my lord, page 85, my lord. I'm sorry, 292. Hello, what is the problem they are facing and what advantage they are taking of this order, my lord? That will Lordship will find at page from page 292, my lord. Page 292. These are the illegalities going on in the farm, and I raised my voice. That is my lord. Page 292, my lord.
Yes.
This is the first letter I wrote, my lord. Subject is show cause notice regarding the fraudulent change in the partnership deed of the Pride Realty and notice to stop all activity at Protect Pride, Bagorbari site. It has come to my notice that partnership deed of the partnership farm Pride Realty has been altered without my knowledge, and my signature
It is
has
referring to the second.
Yes, my lord.
Second partnership deed.
Yes, ma'am. Yes.
Okay.
First one remains, and my signature has been fraudulently done by one, Mr. Swenso, director at Protect Group. In our previous board meeting, when I highlighted this issue, Mr. Vivek Singhal had gone on record to say that he has signed it after you directed him to sign the papers, and that he has done so after an understanding with you. It is between Vivek Singhal and Mr. Jalan. This means you were in full knowledge of this arrangement and therefore are an accomplice and part of this fraud which has taken place. This fraudulent signature has been done without my knowledge, without informing me, without my approval to add Mr. Vivek Singhal and others as partner to try and take over the partnership farm in an hostile takeover manner. The project Protect Pride further launched by the partnership farm Pride Realty is also without my approval or information as the original partner of the farm, whose sign was fraudulently done to change the partnership arrangement and launch this project. Implying this project Protect Pride is also unauthorized and illegitimate. Please tell me your stand as a written reply on the above fraudulent signature and change in the partnership deed, and thereafter launching a residential project and having started work without my knowledge or approval. In the meantime, I ask you to stop all activity on the land at Bagorbari and reply to me with within 4 business days from the receipt of this letter. Failing to do so will force me to file an FIR and take legal action against you, which will be followed by me informing the municipal authority, RERA office and loan financing banks and customers that have been cheated due to his fraud and the illegal nature of this project. I hope you take this notice with utmost sincereness.
We'll continue.
Madam.
Please, madam. My lord, in regards to item number 7, lordship, I have a pair lordship. This matter may be adjourned today. Mr. Samaria have some personal difficulties here. Let the court premise. My friend is there, lordship.
Item number 7, on request of learned counsel for the petitioner, which is acceded to by the learned counsel for the other side. Let this matter be listed again on
After vacation. 16th of July.
16th of July.
Lordship, another pair, lordship. Item number 5, lordship. Your lordship allow us to go through the record to correct the pagination. That maybe.
Okay, you are allowed.
Lordship.
So I'll take just 15-20 minutes and will conclude my note. Just 15 minutes.
Whether the question, to decide the question,
Yes.
whether at this stage ex parte stay may be granted.
Not ex parte, but after hearing the parties.
There are others.
Many other parties are there. So
No, they have filed a caveat. Main contesting candidate is here.
But other partners are, you are representing all partners.
One has been left out. That is another objection that is.
No, that about that party, my lord, I'll clarify. What has happened before in the second,
No,
my lord.
you answer few queries.
My lord.
Like this is an application under Article 227.
My lord.
Scheme of Arbitration Act provides for remedies under such circumstances. In Section 9 petition, the other side has obtained an injunction.
My lord.
You have challenged that
In appeal.
in appeal.
My lord.
So the appellate court is seized with the matter.
Right.
You have raised the same thing during the pendency of the appeal before this court. Suppose this court assume jurisdiction in 227 application and decide it, appeal would become infructuous.
My lord, I have not, that is what I am trying to point out to you, lordship, that before the appellate court, I have not raised the same issue. It is the court which has gone into the detail on merit. I never wanted the court to write a huge judgment. I simply said that kindly grant me a stay of the interim order. My lord, while passing interim order, your lordship passes an interim order in the first appeal, second appeal here, while exercising civil jurisdiction, my lord. Your lordship doesn't go into the merit of the case. Your lordship only sees whether in terms of the, my lord, the principles of order 39 rule 1 and 2, there is a prima facie case to grant a stay. And then if there is irreparable loss and injury and other two factors are in favor of me or not, that much only.
No, that prayer was made in Section 37 application.
Yes, madam.
What is the remedy? I suppose that is refused.
Madam, I have got no other remedy except 227.
And 227 is very limited jurisdiction.
Very limited. I am trying to bring my case within that limited scope, my lord.
So if I decide this matter
My lord.
today itself,
My lord.
it would amount to granting you the final relief.
No, my lord. That is what I'm saying. That is what I'm trying to, my lord, possibly I couldn't convey. I am not saying that the issues which are to be decided by the appellate court should be decided by this court. I am only saying.
No, before appellate court, there are two issues only.
My lord.
Whether the freezing order was right.
Yes.
Whether exclusion from interference
My lord.
by you was right. These are the only two issues.
True, my lord.
You are conceding one of the issues before this court,
Yes.
that you are not pressing the first one.
Yes, my lord.
Second issue, if I decide now, what will remain in the...
My lord, there are cases where in appeal, my lord, there is a stay of entire judgment of the trial court. It is not necessary that.
Appeal is barred under 37(3).
Yes, no, I'm not. That is why
There
I'm
cannot
in
be.
appeal. I'm not in appeal, my lord.
You are on 227 application.
Yes, my lord.
Where the jurisdiction is very limited.
Limited, my lord. I want to just impress upon your lordship that in a very limited jurisdiction, your lordship will examine
Whether that limited jurisdiction may be exercised without issuing notice to some of the partners,
my lord,
whom you have made.
They have deliberately made it an, my lord, strategy that they will appear for only for 1 and 2. The person who was contesting, my lord, he is before your lordship. Person who is my learned friend appear for all of them before the court below.
No, he is a counsel only.
True.
He will appear only.
I'm talking about the party. Party has engaged a counsel for all of them in the appellate court below, but before the high court only in respect of one. That is the purpose. So that the interim order, my petition will become infructuous if your lordship doesn't consider my claim.
How it will become infructuous?
It will become infructuous because if appeal before the appeal is heard on merit. During the pendency of the appeal, whether I should be debarred from participating in the business, that is my only prayer. I do not want to say that I want to interfere, but the fact remains that here is a case matter where I have written to the bank and pointed out.
But the order of the lower court, that is Section 9 court,
my lord,
is a order ranging about 100 pages.
Yes.
So to consider that a hearing would be, lengthy hearing would be required.
By the appellate court, my lord, yes.
Even by this court to grant you.
My lord, whatever the court has decided, issue is very simple. Whether, my lord, number one, whether I am a partner in the partnership firm.
Oh, that is
answer is yes. Whether I have got a stake of 40% by the first one, 60% by the first agreement, and 55% by the second agreement. That is also yes. Now, the third question is whether I should be debarred during the pendency of this appeal from participating in the business and which they are succeeding in doing, my lord,
Participation
under
is
the guise of this order, my lord. In all business, my lord, at the end of the order, the court has passed an order in all concerns. I am out of all the business. That is the final result of the case, my lord. Should this order remain during the pendency of the appeal is the only question lordship will decide. Your lordship will not decide whether the court was right in passing that order or not in this revision petition.
no,
Only
whether that can be decided today without issuing notice to other.
lordship can issue notice. My lord. What I am saying is during the pendency of this revision petition, your lordship can pass some order so that I can participate. Whether I can be, my lord, let them say that I do not have any stake in the business. Let them say that I have got no right to participate in the business.
Since when you are ousted from the affairs of the partnership?
Section 9 final order, my lord.
No.
First ex parte order, there was no order to debar me from participating by virtue of this kind of order.
When was the section 9?
1912, my lord.
1912.
24.
So since
No,
Since-
my lord. 1912 is the ex parte order, my lord. 1912 is the ex parte.
no, my query is
My lord.
since when you are ousted from the
17th February 2026. That is the final order passed on section
but
9.
before that the interim order was against you.
No, in interim order, there is the difference, my lord. In the interim order, there was no order.
Second part was not
Not there, my lord.
Okay.
Not there.
Okay.
Now you are taking advantage of what has happened, my lord.
What is the date?
Date is 17th February 2026. Lordship will permit me just to show two documents, my lord.
17 February 2026 is
My
the
lord.
order 9.
Yes, my lord.
Order
Final
on
order.
section 9
Yes, my
petition.
lord. Yes,
You preferred an appeal under 37.
my lord.
37 did not allow. Then you are before that.
Yes.
Okay.
My lord, Lordship will give me just a couple of minutes. I'll just want to
Yes.
show two documents, my lord.
Yes.
Lordship may kindly turn to page. Page 82, my lord. Just two documents I'll show, my lord. My lord, difficulties arising from, my lord, two sides. One, the other stakeholders in the firm are depriving me of my right to participate in the business and all these concerns, 6, 7, my lord. And second, the bank is, my lord, in collusion with the respondent. I'll just show, my lord, just two documents, lordship will kindly see the conduct of the bank. And it is because of that non-interference. If I tell the bank that kindly rectify it, they will say there is an order not to interfere. So I cannot interfere in an action by the bank which is against my interest. That also amounts to interference. Lordship will kindly see page 82. This is the letter I have written to the bank.
What is this?
Page 82 is the letter of 14/5/2024. I have written to the bank for the first time that these are the difficulties for which I want that bank should freeze the account. Problem arose from here to the other side, my lord. Lordship will just allow me to read this, my lord. Though through this letter, I wish to inform and notify certain crucial things which have become known to me and which is a matter of grave concern. It has been found that in one of my groups, on one of our group's partnership firms, Pride Realty, certain members, namely Manoj Kumar Jalan, Vivek Singhal, who are also directors, partners of our group sister companies and partnership firms, and are also part of the management of the company, they have committed a signature fraud in partnership deed to try and take over the firm in a
Now a dispute is going on between partners.
Yes.
Partners a dispute.
Yes.
If suppose stay is vacated,
My lord.
how you intend to?
My lord, dispute is going on, but because of that dispute, my share in the partnership remains.
Yes.
Till it is decided whether only because there is a dispute is there between the partners, one of the partners can be deprived of his right to participate till the dispute is settled? That is the question, my lord. By this letter, my lord, I am just trying to point out to your lordship that I have written to the bank that kindly freeze the account, but because these are the illegalities being committed inside the farm.
This, this issue was decided.
This issue was decided. In fact, my lord, initially, what I want to show from here is, my lord, initially while responding to this, lordship may just have a look at page 85 for a moment, my lord. Bank first response. Page 84, my lord.
Page 80.
In response to this request that you see they are diverting the fund, etc., etc., page 84 is the response of the bank. Has your lordship seen my page 84?
No, in this CRP,
My lord.
IO,
My lord.
your limited purpose for which you have approached this court is
My
that
lord.
during the pendency of the appeal
My
preferred
lord.
by you under
My lord.
section
My
37,
lord.
the second part of the stay granted
Absolutely.
under
Section 9.
9.
My lord.
So we will concentrate only
Yes.
that much in this.
Exactly, my lord. That is what I am pointing out. When I write to the bank, they respond by this letter at page 84. They say that you are a partner in these farms. Now, soon thereafter, when I write the second letter at page 97, they say that you are not a partner in these farms. On what basis? On what basis, my lord? This is the role of the bank. And if I insist the bank that kindly point out why you are not.
No, therefore, this court has to go into the facts. Under what circumstances you were restrained. Suppose that restraint is removed today. You will immediately go to the bank by filing an application for freezing the account again.
I am conceding.
Because that was your conduct
No, my
earlier.
lord. My lord, that is why I am conceding before lordship. Subsequently, we filed an application saying that we do not want to, and we want to give an undertaking also. Undertaking we have already given. We are not going to freeze the accounts. That is why I am saying, my lord, so far as first part is concerned, I am conceding that I do not want that the flat purchasers should suffer.
Yes.
Business should suffer. Their financial transactions should suffer. That I do not want. But at least I want that I should be allowed to participate in the affairs of the business, whether by an order of this nature, I can be deprived of my right to participate, my lord. You do not say that I am not a partner. You do not say that I do not have a stake in the partnership farm. Even if you say that, no, you subsequently have challenged this reconciliation, all right. Then by the first agreement also, I am entitled 60%. Today I am out, my lord. And now
60%?
Yes, my
that
lord.
20% in.
No, 40% is direct. And the remaining 20% also through a company. I am a director there. And my lord, the basis for challenging the reconciliation is very simple. My lord.
You are alleging fraud.
No, my lord. I gave a power of attorney to my brother to act on my behalf. But there is a line in the power of attorney that whenever you take any decision, whenever you act on my behalf, take an approval from me through an email. Admittedly, without this approval from me, they have reconstituted. That is the ground for challenging the reconstitution, nothing else, my lord. This is on record.
Okay.
They are only for the purpose of taking an objection, my lord. They say, let's see, you have challenged the reconstitution. Even if I challenge the reconstitution, I go back to the original agreement. It's not that by challenging reconstitution, I am out. Now you have obtained an order of a blanket nature by which I am out. Page.
Yes.
My lord, just one moment, if your lordship kindly permits me to show, my lord. Page 93 is the In fact, my lord, what has happened, my lord, chronologically, what has happened? Initially, there is a dispute. I wrote to the bank that freeze. Bank has frozen. Thereafter, there was a negotiation between the parties, my lord. And then at that stage, the respondent wanted that he should be, as a condition, he should be made the authorized signatory for all financial transactions. We made them. Then we sat in a in a negotiating table. Then it was decided that entire Pride Realty business will go to him as part of the settlement. Settlement was arrived at. All of us have signed. He has also signed. What is the settlement? 90. Just, my lord, for a moment, Lordship has a, if your Lordship has a look at page 90. This is the settlement. Today they do not want to adhere to the settlement. It is signed by all of us, including the respondent. Page 90 is the settlement, my lord. Page 90, my lord, if your Lordship goes, I'll just take your Lordship to the third line, serial number 3. Protect Pride, a partnership firm will be 100% given to Manoj Jalan. I am giving 100% of Protect Pride to you. The firm in respect of which you have filed the case in your section 9 petition, I am saying that there is a settlement between all of us. All of us have signed. I am giving 100% of it to you. And this is a valid settlement, my lord, in terms of the provisions of the Mediation Act 2023. Both of us, all of us will have to adhere to it. Even after that, when they do not accept this, my lord, then I had to write again to the bank, pointing out all those illegalities and financial irregularities they are committing, my lord. Freezing. But not for freezing. I said I don't want freezing. But earlier he was made the authorized signatory. Now you please redo the KYC, etc. And in terms of the stake of each individual, each partner, according to their stake in the partnership deed, or according to his share in the companies where there is a company, my lord, you reassign the signatory. Now bank is in collusion with the respondent, and the bank is not acting upon this request. Then they find it difficult, and then they approach the court under section 9. And when I undertake, let's see, I'm not going to freeze. You are showing the difficulty that the flat purchaser will be in difficulty because of the freezing of the account.
When was the order, section 9 order was passed?
Section 9 order was passed on 17th of February 2026.
Still it is.
My lord.
3 months have lapsed.
3 months have lapsed. That is why I approached this on the court below for a stay. I did not keep quiet, my lord. I immediately filed an application for stay also. My lord,
And when the impugn order has been.
It has been passed on 20th of May 2026.
Yes. Anything else?
That's all, my lord.
Yes, Mr.
And as part of the Partnership Act also, every partner has a right. Section 12. And it is under section 12, my lord. In the conduct of the business, every partner has a right to participate. Now you have obtained an order, it is against section 12 of the Partnership Act. I am totally, my lord, that's what I am trying to project before Lordship. I am totally out of all the concerns. You have projected difficulty in respect of one firm and obtained an order in respect of all sister concerns, a blanket order. And I'm out of all the group companies and concerns. Whether that is permissible in view of the provisions of the Partnership Act, the agreement between the parties,
Yes, Mr. Dev.
Well, first of all, my lord, I would have urged the court not to venture into this at all because any finding that your lordship returns may prejudice either of the sides in the appeal. Now, my lord, just quickly 5 points to make. My lord.
No, you address their submission that admittedly they are partners.
Is that
How can they be outstayed?
I'll address that. Address that. But before that, my lord, just 3-4 points. My lord, I'll come to that straight away. There is no doubt that provision in the Partnership Act, but there are numerous authorities which have said that wanton misconduct on the part of a partner, which has the tendency to sort of harm the partnership firm itself, the courts are empowered to grant restraining orders. And those are aspects which the learned commercial court has taken note of. Our submissions have been considered that what the petitioner number 1 has done so far, writing to creditors, writing to banks to freeze accounts, approaching courts on numerous occasions to stall functions of the projects, etc., would compromise, would come within the meaning of wanton misconduct. Now, once there is established, once wanton misconduct is established, the courts have consistently held that there can be restraining orders even against the partner. Now, that is something which is on facts, which pertains to the merits of the appeal. Now, what I'm trying to drive home is this one. First of all, the appeal is pending where both the directions, be it the direction to defreeze or be it the direction restraining them to interfere with the affairs of the company, are pending before the appellate court. Now, at this juncture, they are perhaps trying to find fault with the second direction. Now, appellate court says at paragraph 20 of the impugned judgment that these are matters that we will consider. Page 759. Para 20, my lord. After taking into consideration all the above aspects, above facts, this court is of the view that the pleas taken by the petitioners for stay of operation of the impugned order relates to the merits of the case, and such pleas can be decided only during hearing of the concerned appeal. Yes. Now, so, my lord, at this juncture, should this court, because ultimately to stay the order, your lordship has to fall with the order of the commercial court. So the question is, should this court at this juncture under Article 227 visit the impugned order and see whether that second direction is right or wrong, permissible under the Partnership Act in the facts and circumstances of the case? So that, in my respectful submission, would be entering into the merits of the case in a revision arising out of a stay order. Now, I will place judgments on the scope of 227 when it comes to orders passed under Section 37 in a while. That is one part of the, and that is something which I've taken a cue from what has fallen from your lordship, because ultimately to tinker with that order, your lordship has to venture into merits. And any observation that is made today is bound to affect maybe the respondents or the petitioners for that matter. So therefore, my lord, I would suggest that these questions should be agitated before the appellate court during the hearing of the appeal. That's number 1. Number 2, my lord, I am on caveat on R1 and 2. My learned senior friend is correct. I was also holding the brief for one of the brothers. But insofar as the other companies are concerned, as on today, I'm not on record. So what they're urging is stay of that particular direction of the Section 9 order. Now, this also happens to be the final relief in this application. If your lordship sees the prayer here at page 44, Manoj, 41, I'm sorry. Volume 1.
Yes.
Now they pray for setting aside of the impugned order 25/2026 passed by so and so in Miss case so and so in Miss arbitration so and so, and be pleased to pass an appropriate direction to stay the operation of the order dated 7/2/2026 passed in Miss arbitration case number 205 of 2024. So this is the final relief here. And today the petitioners are pressing for a like order at an ad interim stage without even issuance of the notices to the other respondents. So it, in my respectful understanding, my lord, it tantamounts to seeking a final relief at an interim stage, at least insofar as this civil revision petition is concerned. Now, my lord, before I venture further into the facts, my lord, another aspect, like I've pointed out, this revision or the appeal for that matter may not even be maintainable in the absence of one of the original partners, which was a company associated in India Private Limited, and which was represented by a family elder of the petitioner's family, who is Indumati Singhal. Now, there is a reason why that particular party has been deliberately left out from the array of parties.
What it is known as Associated?
Associated India Private Limited, represented by Indumati Singh. Well, I'll just show the conduct has not only been wanton prior to the institution of the proceeding, even during the proceedings, my lord, they have indulged in fraud, to say the least. Now, if your lordship has page 229 for a moment.
Yes.
Now, this was the original application for modification. Here, your lordship finds
Before the
trial court, before the commercial court.
yes.
Now, here your lordship finds number 2 applicant who seeks vacation of the ad interim order is Associated India Private Limited, and it is shown represented by Srimati Indumati Singhal. And there is also the signature of Srimati Indumati Singhal. Now, if your lordship takes the other bunch, Malal, I'm sorry to take your lordship through the volumes, Malal. So the vacation application was shown to be filed by Lokesh Singhal and Indumati Singhal. Now page 726, if your lordship takes.
Yes.
170. Lordship will kindly give me a moment. I'm sorry, if your lordship has page 739. But Indumati Singhal later on disputed, sort of disowned the application filed by them, Malad.
739.
739 is that particular order. Petitioner OP number 1, 2, 3 and OP 4 and 5 are represented. Petitioner by filing petition number so and so prayed to extend the interim order, heard and perused. Considering all the aspect, prayer is allowed till next date. The learned so and so filing prayed to withdraw their wakalatnama from the case and also submitted that they have no objection is if pro forma opposite party number 4 is represented by any other advocate. Heard and perused. Considering all the other aspect of the considering all aspects, prayer of the earlier engaged counsel for pro forma OP number 4 is allowed. It is seen that pro forma OP number 4 is now represented by KP Borua, who has filed an application affidavit on behalf of OP number 4, which is still pending for acceptance in view of 2 affidavits filed by pro forma number 4 with contradictory statement. As the earlier counsel of the pro forma OP number 4 has withdrawn his wakalatnama and is no longer representing the OP number 4, the affidavit filed by newly engaged counsel of pro forma OP number 4 shall be taken into account consideration while deciding the application under section 9. So, my lord, Indumati Singhal.
Who is OP number 4?
Indumati Singhal.
She was a pro forma respondent.
She was a pro forma.
All
Now,
not in individual capacity also.
So that application that was filed on behalf of Indumati Singhal, my lord, they have not submitted that affidavit, which I will bring on record now. Now, in that application, she clearly states that my signatures were taken unknowingly and I was made to sign that application for vacating. I do not have any quarrel with the position that the respondent should continue to manage the firm and that my other application for vacating should not be considered as an application filed by me. Now, having seen her stand, my lord, at page 740, your lordship will find, because all this while the projection was everybody is with me. It's only the Jalans who are against me. However, their own grandmother files an application saying that the Jalans, we have a cordial relationship with the Jalans and we should continue. I'll bring that affidavit on record. It was part of the stay application. I mean, objection to the stay. It doesn't find place here. Now, after this at page 740, because she has now sided with the respondent, her name has been struck up. So that now today they can say that I am the majority shareholder. Whereas a component of that alleged majority share has sided with the respondents and have said that we do not have any objection if the authorized signatory continues to operate. So that is another aspect of the matter, because Associated India was a party before the commercial court, and this appeal.
What is Associated India?
One of the original, it's a company, which was one of.
Whether that company exists now?
Yes, it exists. It exists. It exists. In fact, that is the dispute that they were urging. That why was Associated India removed from the original array of partners when by that fraudulent deed of reconstitution? But Associated India itself come forward through Indumati Singhal and says we were rightly removed. We had the consent to be removed as a partner, and we have no objection about new partners being inducted. So their own co-applicant is not before your lordship, and is not even arrayed as a respondent. However, she was a party before the commercial court. Now, coming to the other question, my lord, whether there can be such an order at all. Now, your lordship has seen, my lord, one. I'll just take your lordship through few of the annexures, my lord. First, if your lordship has page 82, which my learned senior friend had already shown.
No, whether there can be an order ousting a partner from the.
Yes.
from participating in business of.
I'll come to that, those judgments straight away. Although I would submit that this is a matter to be decided by the appellate court, I'll show that there are authorities which have said that yes, it is permissible when the conduct is such. And in any case, if your lordship holds that such an order cannot be passed, it amounts to
Deciding.
deciding the appeal under 37th.
Which para?
Paragraph 5, if your lordship first takes up. This was the order passed and was impugned in this judgment. So paragraph 5, from the top, it should be in the 9th line. The sentence begins with accordingly. Paragraph 5 at page 4.
Yes.
Has your lordship found it? Accordingly and add an interim injunction. Paragraph 5, Lord.
Yes.
Accordingly, an ad interim injunction restraining the defendants 1 and 2 interfering in any manner with the agency dealership of Messrs. Mahindra and Mahindra Limited was granted by this court on 8th of August 1980. So this was the order impugned. Now that was the precise argument that was made that I'm still a partner. How can you oust me from the dealings of the firm? Now the discussions your lordship finds at para 30 onwards.
What was finally held?
Lord?
What was held finally?
It was held that under such circumstances, if that is very similar circumstances, my lord, here also the partner writes to the bank, to the creditors. Then Delhi High Court describes it as wanton misconduct by relying on foreign authorities and says that under such circumstances, the order was justified. Para 30 for a moment, if your lordship has.
Yes.
The relevant portion just above those dotted line, Manoj, clause 9 of the partnership agreement. Has your lordship found it?
Yes.
Clause 9 of the partnership agreement clearly enjoins upon all parties to be just and faithful to each other and to render true accounts and information of all things affecting the firm to any party. So the conduct of the defendants in writing letter dated 30th August 1979 to the principals to suspend supplies of vehicles and parts to the partnership firm clearly constituted an act of bad faith. They did so at the back of the plaintiff, obviously with a view to undermine and impair his position as managing partner. Even otherwise, this action on the part of the defendants was injurious and harmful to the business of the firm. Not only that, they also wrote to the banker, Bank of Rajasthan, that a dispute having arisen among the partners of the firm, they, that is bankers, should not honor any check issued by any partner in the firm's account, and authority to operate the account by any of the partners jointly or severally be treated as suspended. This kind of wanton and unruly act was bound to recoil and boomerang on the business of the partnership, as would be abundantly clear from the letter dated 16 September 1979 of Messrs. Mahindra and Mahindra Limited to the defendant defendant firm. In the said letter, the principals of the partnership firm made a grievance of the fact that their banker had declined to negotiate documents under letter of credit opened by them, even though the same was irrevocable. So they threatened the partnership firm with immediate cancellation of the franchise. It is a different thing that subsequently some kind of settlement was arrived at between the parties, and the plaintiff continued to conduct and manage the affairs of the partnership as before. However, the differences and disputes between the two groups of partners were so deep-rooted that the settlement proved to be short-lived, and litigation again ensued between both with regard to the partnership as well as Supreme Motors, the other family concern of the parties. Hence, it is absolutely imperative and essential that steps be taken by this court to preserve the business and goodwill of the partnership till it is dissolved by consensus among the partners or some other viable solution is found. Certainly, the comparative mischief or inconvenience which is likely to issue from withholding injunction will be greater than which is likely to arise from granting it. Now, para 34 and 5 again.
Okay, there are some circumstances.
Yes.
Under which even a partner can be restrained.
Yes. And the circumstances cannot be graver than it is in this case, Manoj.
How?
Manoj, I'll show. First of all, page 82, your lordship has seen that the accounts were frozen for the first time, Manoj. Now, this naturally created panic because all the projects came to a standstill. There was panic among the flat allottees. We were, in fact, the threat of penalties from the RERA was looming large on our heads, Manoj. And eventually, if you're now your lordship has page 85. They go back and forth, Manoj, every time. Page 85, after they gave the letter to freeze the accounts and the accounts were frozen, page 85. May I read this one?
You were made this sole signatory.
I was made the sole signatory and the petitioners have signed it.
Including the present.
Including the present petitioner.
That may be outcome of some compromise.
Yes. Now, if your lordship has page 90, Manoj. Now they say that there was a compromise. Now this is again, the version is full of contradictions. Now page 90, if your lordship sees.
Yes.
They try to sort of bank upon this particular settlement agreement, calling it a conciliation award of sorts. Now, paragraph 3 is very clear, Manoj. Clause 3. Protect Pride is a partnership firm will be 100% given to Manoj Jalan and family. Now, if they want to rely on this document, why are they even bothered with the affairs of this particular entity, Manoj? According to them, this conclusively settles it, Manoj. According to this, the partnership firm in question should come 100% to me. Now, if it comes 100% to me, then why did you again in December shoot the next letter to again freeze the accounts? Page 93. 23rd of September 2024, they entered into a settlement. According to them, my lord, Pride Realty 100% should come to me, my lord. Then what prompted them at page 93 again to approach the bank to refreeze the accounts of the firm? Page 93, my lord. 94, your lordship will find that subtle prayer to refreeze it, or in the garb of compliance with KYC, my lord. Page 94, the last paragraph. If you've already settled it, why did you again go in December to again freeze the accounts?
Okay.
Now this is
just quick response to these 2-3 points. This settlement, they are saying that.
Just a minute. Anything you want to add more?
Yes, my lord. Few more things very quickly. Now, after this, my lord, they say they gave an undertaking. That's the other summary. They gave an undertaking that we will not again take steps for freezing the account. By this time, the interim order of 1912-24 has also come. They keep on writing letters to the bank, my lord, and today the allegation is bank has colluded with me, my lord. However, I'll show from the record, it appears, I will not say collusion, it appears the bank was supporting them because during the operation, while that 1912-24 order was still in operation, it was again frozen, for which we had to come to this honorable court by a contempt application. And at page 69, your lordships will find there's the order where again the frozen accounts were directed to be defreezed.
These accounts are of the.
Yes, the same accounts, Mullah. Today they say we have no business freezing the accounts, Mullah. They've done that once after that supposed settlement. Then even during pendency, they moved.
Yes, Mr.
Yes.
I'm inclined to issue notice only now.
My lord, let me make just a couple of submissions. My learned friend is showing a document that Pride Realty, by way of a settlement you have given to me. Why you are writing a letter? You did not accept that. Please accept it. Take whole of Pride Realty, but leave aside others. You did not do that. If today my learned friend says that he will go by this settlement, I will withdraw this application, my lord. I will withdraw this application, my lord.
So there is a scope of settlement also.
What I am saying is, my lord, my lord, on the one hand, they are saying that you have given whole of Pride Realty to me. Why did you write the letter? Because you did not act upon this settlement. Settlement says take whole of Pride Realty, but leave aside others. You did not act upon that. And I was compelled to write to the bank again. Not for freezing. And the other letter of the bank, they are showing bank on its own bank has written, because they are not doing the updating the KYC. My lord, one important aspect I have to point out to your lordship. It is being projected that I am creating disturbance, and that is why reliance on their judgment. I am not against the firm or the company. I am against you, unlike the facts of that case. And the kind of apprehension based on which in that case the court passed the order is not there in the case moment I concede the first prayer. That your apprehension was that I'll write to the bank for freezing. I am conceding that I am not writing to the bank. Lordship may write down my concession. So if that apprehension goes, they are not entitled to an order. My lord, there is this. I am just relying on one judgment of my lord Bombay High Court in a Section 9 petition. My lord, what the Bombay High Court has said, my lord, just paragraph 16, my lord, just one small paragraph. Can they debar me totally? Just couple of minutes, my lord. This is para 16, my lord.
Yes.
My lord, lordship, para 16, my lord, lordship means keep the first few lines. The sixth line, my lord, besides, starting from the word besides, my lord.
Yes.
Besides the issue which has been resolved by the lower court, as is rightly contended by the counsel for the appellant, in terms of Section 9 of the Arbitration Act. Lordship has got, my lord.
Yes.
I am reading from the sixth line, my lord. Besides the issue.
Yes.
Besides the issue which has been resolved by the lower court, as is rightly contended by the counsel for the appellant, in terms of Section 9 of the Act, the court has power to pass interim order for matters provided therein, that is Section 9. Essentially, such power is exercised for preservation of the property and not to oust any party of its legitimate entitlement. Counsel for the appellant has rightly relied on Section 12 of the Indian Partnership Act 1932, which provides that every partner has a right to take part in the business, subject, however, to the contract between the parties. It is possible to argue that arrangement arrived at on so-and-so is a contract between the parties, but for reasons already recorded earlier, I am not inclined to accept that the negotiation held in that meeting were translated into a concluded contract. So long as there was no concluded contract, the terms referred to in the memorandum of understanding cannot be, that is in the facts of that case. Now, what I am saying is, my lord, they have relied on a judgment saying that no, in a given case, a partner can be ousted, but that is for the purpose of protecting and preserving the interest of the firm when it is found that he is conducting in such a way that it is going against the interest of the firm. I am not against the firm, my lord. My case, my defense in the Section 9 petition is not against the firm. Your conduct and your apprehension that I may freeze the accounts and you may suffer, that is why there is a need to prevent me, is no longer there when I concede that I am not going to write to the bank to freeze the accounts. Thereafter, should there be still an order to prevent me, that means you are ultimately getting an order to prevent me from participating in the affairs of the business against the provisions of Section 12 of the Partnership Act, my lord. This is the result of this order Section 9. Otherwise, their apprehension that I am creating disturbance in their business by writing to the bank that please freeze the accounts where the the flat owners have deposited their money. That apprehension is not there, I am conceding. Thereafter, what is the need again to prevent me, my lord? If your intention is to prevent me and no other, my lord, relief you want, then it's a matter is different.
No, I am not rejecting your contention now,
My lord.
but the contentions
I'm
which
saying that your lordship will pass a stay of section 9 order. I am only saying that your lordship will make some modification so that in terms of section 12 of the Partnership Act, I can exercise my power, which is legitimately I am entitled.
no, not today. We are issuing notice only. Fixing a date. Let the notice be
In the meantime, the appeal will be coming up for hearing.
when.
Even better.
So you can raise the contention in the
Well,
appeal.
this contention I will be not raising in the appeal, my lord. Appeal I will be raising contention on merit. This is not on merit. This is on the requirement as to whether a stay should be granted or not. If at least a modification should be there of section 9 order or not. That is the issue before your lordship. This issue is not to be agitated before the
After hearing both sides.
My lord.
After hearing both sides.
My lord.
I am of the view that
My lord,
least
here, Mr. Jalan is the only contesting party. Indumati's name they are referring, my lord. First of all, she was not a party by name in any of the proceedings. It is only a associated India Private Limited where she was a director. Now, in the section 9 proceeding, initially she filed a reply against the applicant. Subsequently, she changed it and she came in my favor. And so far as the appeal is concerned, there she has filed on her own an application for deleting her name. This is how she is out. And why should I make her party? She has already struck out her name.
No, but the respondents whom you have made parties.
My lord.
Forgetting about the Indumati or the associated company, the respondents whom you have made party, they are entitled to
My lord,
get
true.
not.
My lord, true. They are entitled to a notice. But today I am praying for a protection that lordship will make small modifications so that I can participate, because whatever they have to say, my learned friend has already submitted. He is a main contesting person, Mr. Jalan.
We are issuing notice, take steps.
Then this appeal will become, this petition will become infectious in a way, because appeal will be hard in the meantime.
No, in July or immediately after opening. 20 July. I'll pass a detailed order. Why I am not granting ex parte ad interim relief at this stage. 20 July, you take steps for issuance of notice on all the respondents by speed post as well as by usual means. Wait. Bank is appearing. Who
All are before your lordship, my lord. Lordship can always pass an order.
remains?
Some will always remain so that the matter is delayed till the appeal is heard, man. I'm only making my submission, my lord. Manoj Jalan is the main contesting party. He has filed the application under section 9. He is before your lordship. Others are pro forma, others are respondents.
You can represent Mr. Deka.
Six I can represent.
Because 6 is the
5 and 6. I'll take instruction. Those are company.
Lordship will kindly see this. All these are represented by Manoj Jalan. Before he is before your lordship. This is only a technicality to avoid the interim order.
20th of July. Wait for detail order.
We'll keep the issue of maintainability over the Supreme Court as
And dictate the detail order in
Yes.
chambers.
Should I place this today or not? The Supreme Court judgment that 227 should not be invoked in so far as ordered again.
You can give all whatever you want.
No, if not required,
My
will
lord,
not trouble
in
your
my lord, in that
worship.
case, there is one judgment, there are two judgments in fact, where the Honorable Supreme Court said in a matter arising out of section 9, your lordship's power under section 227 is not barred in an exceptional circumstance, and where the act of the other side is not bona fide. These are the two grounds on which your lordship can interfere under 227 also. That judgment I'll
Give that
I'll
judgment.
tell you. On these two counts, the lordship can always entertain a petition under 227. And that's why I'm saying, my lord, till the matter is heard, lordship will make small modifications so that I can participate in the business. I'm not going to interfere anything with their business.
Next date is on 20th of 7. Let me go through the wait for detail orders.
Obliged.
Item 40.
Yes, to learn.
Item 9.
May I please, your lordship? Sir, lordship, here, I'm sorry, I'm appearing through VC today because I'm not keeping good health, lordship. Here, lordship, what has happened? Here already this NDPS case, lordship, all other witnesses are over, only the IO is left over. Now, on the last occasion, lordship, when this matter was posted before the trial court has been newly constituted special judge NDPS Assam, Kamrup Metro, lordship. Now, their public prosecutor is not there. So, no trial could take place on that day.
A public prosecutor is not there.
No, he is not appointed because the court has been newly constituted, lordship. And on 29/6, again, this matter is fixed. So 29/6, we are hopeful this Monday. 29/6, we are hopeful that maybe the learned public prosecutor will be appointed. And
Then we
trial
will fix this matter after 29/6.
Lordship may fix it on 27, lordship, on the reopening, after reopening, lordship.
Okay. Lord Mr. A. Bhattacharya, learned counsel for the petitioner. Also Mr. K. K. Das, learned additional public prosecutor. The learned counsel for the petitioner submits that the case before the trial court is fixed on 29/6/2025, 2026,
2026.
and therefore pays for listing this matter after the said date. The prayer is allowed. Let this matter be listed.
27, lordship.
20 July.
20th July.
Let this matter be listed again on 20th of July.
I am declared, lordship.
Item 40.
Heard Mr. A. M. Lord Bhuya, also heard Mr. M.Z. Kadir. Both the learned councils have submitted their written gist of submissions and written gist of their arguments,
Along with the
along with the rulings relied upon by them. The hearing concluded, judgment reserved.
Obliged.
Bangore to nothing else. Chamber of the Blue. Yes.
May it please your lords.
Item number 10.
Item number 10, my lord. PRS bill applications, my lord. My lord, that is a commercial quantity, my lord. Now, my lord, before going to the, my lord, facts of the case, my lord, I'm coming to the, my lord, chronology of events, my lord.
Mr. Chaudhary, Dev Chaudhary, will you be arresting him? Do you require his?
Lordship, it would require his custody.
He is required. Okay.
Because in spite of various communications from 22 onwards, 2022, he is evading. And he is the purported receiver.
Yes, Mr. Bush.
My lord, here, my lord, date of incident is, my lord, 13/3/2022, my lord.
Yes.
Yes. My lord, from 13/3/2022, my lord, from the date of incident, my lord, it is more than 4 years, my lord. As on today, my lord, 4 years, 3 months and more than 4 years, 3 months, my lord. Now, my lord, that is the final report, or my lord, that is the final complaint, my lord. That is, my lord, submitted by the investigating agency on, my lord, 5/9/2022, my lord.
Yes.
Yes, from the filing of the, my lord, that is, my lord, final complaint, my lord. That is also, my lord, 3 years, 9 months, more than, my lord, 3 years and 9 months.
Yes.
Yes, my lord. Now, my lord, I am coming to, my lord, that is the matter, my lord. Here, my lord, that on the basis of the, my lord, that is some, my lord, information, my lord, NCB, my lord, my lord, during the course of Naka checking, my lord, apprehended, my lord, 2 accused person along with the, my lord, contraband, my lord. And
How much
my
contraband?
lord, they are, my lord, 29,000, my lord, that is the Escaf cup syrup, my lord. My lord, 29,000, my lord.
Okay.
My lord, from there, my lord, they, my lord, apprehended, my lord, 2 accused persons, my lord. One of the accused person, my lord, who, my lord, in his statement, my lord, stated that, my lord, he is in communication with, my lord, another person called Nazir, my lord.
Okay.
Nazir is not.
Who are you?
My lord, I am Apuranjan Das, my lord. I am not Nazir, my lord. I am Apuranjan Das, my lord. So, my lord, he stated that, my lord, he is in communication with, my lord, that is, my lord, Nazir, my lord. And Nazir stated that, my lord, so this is done for Apuranjan Das, my lord, the present accused petitioner before your lordship. Now, my lord, that is apprehended accused person is not known to, my lord, the present, my lord, accused petitioner, who is before your lordship. So it is a total, my lord, that it is the hearsay statement of, my lord, one, my lord, Nazir, my lord, from whom, my lord, he come to know that there is a person called Apuranjan Das. Now, my lord, during the course of investigation, my lord, they have collected some, my lord, the CDR and also, my lord, the communication details which are used by the apprehended accused person, my lord. And there they stated that, my lord, that is the person whose name is taken as, my lord, Nazir. Nazir is in communication with one mobile phone number, my lord. That mobile phone number, when they, my lord, taken, my lord, that is the details, my lord, CAF, my lord, that is the customer's application from, my lord, they have come to know that mobile phone belongs to one Mr. Atish Kumar, my lord. And, my lord, as because, my lord, during the course of investigation, they stated that one NCB case is there, my lord, NCB 2/2022, my lord, where also that mobile phone was, my lord, involved, my lord. From that, my lord, they stated that, my lord, this is the number that is, my lord, which is, my lord, registered in the name of one Atish Kumar, is used by this person, Apuranjan Das, and it is the number of Apuranjan Das.
No, on what basis they are saying?
Yes, my lord, because, my lord, he stated, my lord, that, my lord, Nazir told him that it is made for Apuranjan Das, man. Totally hearsay evidence, man. And I am, my lord, placing from the, my lord, that is the complaint, my lord, what they have, my lord, filed, my lord. Not only in the complaint, my lord, the investigating agency, my lord, they, my lord, filed, my lord, one, my lord, that is the, my lord, that is opposing to grant the bail, my lord, one affidavit in opposition thereof, my lord, where also, my lord, they have stated, my lord, categorically stated that, my lord, it is in page 102, my lord, from in para, my lord, 9, my lord.
Yes.
Yes. That mobile phone number so and so identified, my lord, para 9, my lord. Investigation being linked and used in connection with the petitioner activities was found to have repeated communications with mobile phone number so and so identified to an associate of Jolil and mobile number so and so connected to one locating the owner of the truck and so and so, so and so, so and so. Now, my lord, here, my lord, entire thing is based on, my lord, that is a hearsay statement of one person who is, my lord, in communication with the apprehended accused person. He stated, my lord, that is the contraband will be delivered to the present accused petitioner based on a, my lord, mobile phone communication which is registered in another person's, my lord, name, my lord. I am not the, my lord, owner of the truck, my lord. I am no way associate, neither, my lord, that is the, my lord, constructive possession, nor, my lord, that is the conscious possession is applicable in this matter, my lord. This is my lord, the first contention before your submission, before your
Neither
lordship.
that mobile number is registered in your.
Yes, my lord, that is not registered in my name, my lord. It is in their complaint, my lord. They have stated, my lord. My lord, I am, my lord, relying this on the basis of the complaint, my lord, where it is, my lord, clearly stated, my lord, that it is belong to, my lord, that is the Atish Kumar, my lord.
Anything else?
Yes, my lord. Now, my lord, secondly, my lord, in the para 10 also, my lord, they have also, my lord, stated, my lord, the fact that the customer acquisition from of mobile phone number so and so stands in the name of Atish Kumar doesn't establish that the number was not actually being used or on behalf of the petitioner. Totally purely and, my lord, assumption by an central investigating agency in this regard, my lord. Now, my lord, in para 11, my lord, they have stated the said mobile number had also surfaced during an investigation NCB crime number so and so, in which Apuranjan was under suspicion. That mobile phone they got in earlier in one case, my lord. About that case, my lord, that is the petitioner is not aware at all, my lord. Now, my lord, they, my lord, on the basis of that mobile phone number, which is registered in other person's name, and, my lord, apprehended accused person who is not known to that person, only he said that I am in connection with another accused person who stated that it will be delivered from that. On the basis of this, my lord, complaint was filed. Now, my lord, may kindly peruse the para 12 of the objection filed by the, my lord, investigating agency, my lord, page 103, my lord.
Yes.
Yes, my lord. This is very important, my lord. That the petitioner has deliberately suppressed from this honorable court that the repeated efforts made by the investigating agency to secure his appearance, the records discloses inter alia that a notice under section 67 of NDPS Act was issued to the petitioner on 6/6/2022. Now, my lord, on 6/6/2022, regarding this notice, I am not aware. I am not, my lord, I am not the recipient of any such notice, my lord. Now, my lord, on B, my lord, another notice forwarded on 29/6/2022. Then 6, my lord, a further notice is used on 2/8/2022, requiring the petitioner to appear on 10/8/2022. Then, my lord, E, my lord, a further communication was 28/2022. Why, my lord, I am stating, my lord, this, my lord, para is important because, my lord, it is the final complaint is, my lord, that is they have lodged, my lord, on 5/9/2022, my lord. And, my lord, that is the last communication they have made from the investigating agency is, my lord, 28/2022 before filing of the final complaint, my lord. After that, my lord, nothing is done, my lord. Only when, my lord, that is the petitioner come to know that something is there, then, my lord,
In complaint, you are named as an accused.
my lord, in complaint, I'm coming to that, my lord. When they filed the complaint, my lord, in the last part of the complaint, my lord, they kept it open, my lord. They kept it open, my lord. My lord may come to the, that is, my lord, of the petition, my lord, bail petition. It is in, my lord, that is the page 89 of, my lord. Page 89.
Yes.
Page 89 of the petition, my lord, para 70, my lord, of the complaint. May I read, my lord, that para, my lord. that it is submitted that the investigation against suspected person, Gudu associated so and so, Oppu Ranjan Das, alias Oppo, Jolil, other persons are there, Lokesh Singh, Trakona, so and so, is still pending. The role of accused person suspects harm as mentioned herein above. Therefore, it is most humbly prayed to grant permission for filing supplementary complaint as and when the suspected persons get arrested. Now, my lord, this is the para 70, my lord. When they file the, my lord, final complaint, my lord, in one para, my lord, they mention this, my lord. But they, my lord, in this case, my lord, my humble submission before your lordship is that, my lord, in this regard, my lord, no separate application is filed, my lord, to my lord asking for, my lord, that is the permission. And my lord, even my lord, this is taken as a, my lord, that is a, my lord, as a, my lord, that is the part of the, my lord, that prayer is taken in the complaint also, my lord. My lord, up to, my lord, 18/3/2026, we have, my lord, order receipt copy available with us, my lord. We did not, my lord, get a, my lord, single order where, my lord, that learned trial court give permission to, my lord, for the further investigation of the case, my lord.
At what stage that case is pending?
My lord, case is pending at the, my lord, trial stage, my lord. Already charges frame. Now, my lord, if we, as because it is a 2022 matter, my lord, this code of criminal procedure is applicable in this case. If it is a case of, my lord, today's, my lord, that is the criminal procedure code, my lord, BNSS, then, my lord, automatically it becomes arbitrary because, my lord, till, my lord, that is the filing, my lord, there, my lord, in 193, my lord, that provision is clearly, my lord, mentioned. In 193 of BNSS, my lord is very much aware, my lord, that is the 193 of BNSS, my lord. It is, my lord, in, my lord, para 9, my lord.
Yes.
Yes, my lord. My lord, 193 is, my lord, report of, my lord, that is the police officer, completion of investigation. My lord, this is the subclause 9, my lord. Nothing in this section shall be deemed to preclude further investigation in respect of an offense after a report under subsection 3 has been forwarded to the magistrate, and where upon such investigation the officer in charge of the police station obtains further evidence, oral or documentary, he shall forward to magistrate a further report or reports regarding such evidence in the form as the state government may by rules provide, and the provisions of subsections 3 to 8 shall, as far as may be apply in relation to such report or reports as they apply in relation to a report forwarded under subsection 3, provided that further investigation during the trial may be conducted with the permission of the court trying the case, and the same shall be completed within a period of 90 days, which may be extended with the permission of the court. Now, here in my case, my lord, as because, my lord, the orders is available up to, my lord, 18/3/2026, my lord, no such, my lord, permission was granted by the, my lord, learned trial court in this regard, my lord. My lord, in the application, my lord, that is the in, my lord, present bail application, my lord, it is, my lord, in the annexure, my lord, that is, my where, my lord, on the immediately after filing of the final complaint, my lord, that is, my lord, in page 91 to 92, my lord, page 91 to 92, my lord, we have annexed, my lord. Page 91, my lord. That is, my lord, after filing of the, my lord, that is complaint, my lord. The order is, my lord, reflected as, my lord. The court record put up today. The investigating officer of the case has submitted offense report under so and so NDPS against the accused person so and so. These are the apprehended, my lord. Seen the same, accordingly, NDPS case is registered and put up for necessary order. On perusal of the court record, it is seen that both the accused persons are under judicial custody so and so, my lord. That is the produced. And my lord, second para case record is put up today, being received so and so. So my lord, there is no my lord permission, my lord, they have obtained my lord after my lord filing of the search sheet. Now my lord, at that point of time, my lord, it is my lord the criminal procedure code, my lord. That point of time, my lord. Though my lord in the my lord CRPC, my lord, what is it now in my lord BNSS, my lord, that part is my lord regarding the time was not there. But my lord, it is from the various my lord authorities of the Honorable Supreme Court. My lord, the settled position of law is that, my lord, though my lord that word is not there, my lord, it is my lord that is the mandatory to my lord take my lord that is the my lord permission from the court, my lord. Now, my lord, I am my lord, many authorities are there, my lord, in this regard. Lordship is very much aware, my lord. I am relying one authority, my lord, that is of 2026, my lord, Pramod Kumar and others versus State of Uttar Pradesh and others. My lord, may kindly peruse the same, my lord. As because, my lord, this is a complaint, my lord. The word is, my lord, also, my lord, complaint here, my lord. It is not the search sheet, my lord. Though, my lord, that is the result is obviously the same, my lord. My lord, may kindly peruse the para 33, my lord. I am not taking, my lord, very much time of this honorable court, my lord, precious time. My lord, para 33, my lord. So what is the, my lord, position of, my lord, that is the particular section of CRPC, my lord, 173(8) of CRPC, my lord. Because 22 matter, my lord. Yes, my lord.
Yes.
Para 33, my lord. May I read, my lord?
Yes.
In the light of the legal position as settled by this court through the above judgment, it is safe to say that the power to direct further investigation in a case rests solely at the discretion of the magistrate stroke court concerned. Here, my lord, I am special court, my lord. In the event, my lord, the police oblique investigation agency is of the opinion that further investigation is necessary in any particular case to cull out complete facts and truth in the case, it is binding upon them to file an appropriate application before the magistrate court without directing an order for further investigation by themselves. Once such an application is filed by the investigating agency, the magistrate court would apply its judicial mind in light of the facts and circumstances of the particular case and the reasons demonstrated by the investigating agency in order to exercise its discretion or exercise of its power to decide whether or not further investigation is to be ordered under the purview of section 173(8) of CRPC. So, my lord, here, my lord, for further investigation, if, my lord, though it is a, my lord, that is the final complaint from it is, my lord, file, if it is, my lord, treated as a search sheet, my lord, then also, my lord, this, my lord, permission is required, my lord. And there is no permission from, my lord, last 2022, my lord.
Okay.
My lord, here are other, my lord, that is, my lord, court, my lord, analysis, my
Now,
lord.
why are you apprehending your this?
Yes, my lord, because, my lord,
Because of the entry
my lord.
at para 76 of the final complaint.
Yes, my lord. That part is, my lord, there. And even, my lord, in, my lord, their objection, my lord, they stated, my lord, that, my lord, his, my lord, my lord, that is, my lord, that is the custodial interrogation is needed, my lord. And, my lord, the investigating agency, my lord, in this regard, my lord, they have, my lord, relied upon some authorities of the Honorable Apex Court also, my lord. Here, my lord, other, my lord, that is, my lord, in from page, paragraph, my lord, 19 to, my lord, para 22, my lord. They relied upon some authorities, my lord, known to your lordship, my lord, very well, my lord. That is there, my lord, from 19, my lord, 20, and, my lord, that is, my lord, the 22, my lord, it is, my lord, regarding, my lord, the para 37, my lord, and, my lord, that is the custodial interrogation mainly. Now, my lord, there they stated in para 21, my lord. Para 21 is a, my lord, contrary, my lord, that is the, my lord, authority, my lord, they are relied upon against, my lord, this is Tufan Singh's, my lord, judgment, my lord, landmark judgment of Tufan Singh, where they would like to, my lord, state that, my lord, state of Haryana versus Samarth Kumar, my lord, they stated, my lord, that as because, my lord, it is a, my lord, bail stage, and, my lord, it is the case related to, my lord, this commercial quantity. That should not be, my lord, in the time of, my lord, that is the, my lord, is a bail, my lord, it should not be, my lord, taken. Now, my lord, it is not a, my lord, bar, my lord, because, my lord, Supreme Court, in, my lord, different occasion after this, my lord, Samarth Kumar judgment, my lord, they granted, my lord, anticipatory bail, my lord. In this regard, my lord, I am, my lord, relying, my lord, one, my lord, recent, my lord, the Supreme Court, my lord, case, my lord, in this matter, my lord, where, my lord, the Samarth Kumar case is, my lord, also, my lord, discussed, my lord. My lord, here, my lord, it is a, my lord, matter, my lord, which is disposed of, my lord, after Samarth Kumar, my lord, 23/8/2024, my lord. That is, my lord, first, my lord, interim bail was granted by Honorable Supreme Court, my lord. And, my lord, thereafter, my lord, it is, my lord, made absolute. Now, my lord, relevant paragraph is, my lord, 3 and 4 of the interim order. My lord, may kindly see, my lord, that is the page 2 of 3 of the interim order, my lord. Regarding, my lord, law point, my lord. Prima facie, my lord, para 3, my lord.
Yes.
Yes, my lord. May I read, my lord? Prima facie, it appears that the contraband in the form of opium weighing so and so, office store was recovered from one so and so seems to have disclosed the name of the present petitioner in his statement. Here also, my lord, commercial quantity. Here he is not my disclosing my name. He said that, my lord, I have come to know from this person. This person said that, my lord, it will be delivered to me, my lord. Here, my lord, directly said to, my lord, it will be delivered to that person, my lord. Petitioner statement recorded under 67 of NDPS Act. He stated that 5 kgs of contraband was to deliver
Where
to
are
the
you
petitioner herein.
Where are you reading?
My lord, it is in the, my lord, next piece, my lord. That is the when, my lord, interim, my lord, order was granted, my lord. There, my lord.
Now the judgment cited by you
Yes, my lord.
is Gursevak Singh,
No, my lord, this, my lord, Sukhpinder Singh versus, my lord,
but you have
state
given
of, my lord, then, my lord, that was my Gursevak is, my lord, another, my lord. It is another special court judgment, my lord. Apologies, lord.
yes,
Yes. My lord, kindly see, my lord, para 3 and para 4, my lord.
yes,
Para 3, my lord, there is a facts, my lord. It is also, my lord, commercial quantity. Similar to the, my lord, same, my lord, that is, my lord, in 67 statement, taken the name. Now, my lord, in, my lord, para 4, my lord. What, my lord, the NCB is relying, my lord. That is, my lord, state of Haryana versus Samarth Kumar, my lord.
yes.
We are conscious of the decision of the court in the case of state of Haryana versus Samarth Kumar, reported in so and so, so and so. However, if the only evidence against the petitioner is the statement of co-accused recorded under 67 of the NDPS Act, which otherwise is not admissible in evidence, then probably we may have to consider the plea of the petitioner for anticipatory bail.
Okay.
So that is not a bar, my lord. Regarding that, my lord, law point. Now, my lord, regarding the, my lord, delay part, my lord. After, my lord, that is a 4 years, my lord, of more than 4 years delay from the commencement of that, my lord. My lord, I am relying, my lord, that is, it is not, my lord, it is also related.
Delay on whose part?
My lord.
Delay on whose?
Delay on the part of the investigating agency, my lord. They have not, my lord, taken, my lord, that is the permission, my lord. Now, my lord, when I have come to know, I have appeared before this honorable court. Now they stated that no, he may not be granted the, my lord, privilege of the anticipatory bail because we need it, my lord, to find what, my lord, that, my lord, particular, my lord, that is the, my lord, the SIM card and, my lord, mobile. That SIM card is not belong to me, my lord. Only that part, my lord. Now, my lord, that is the regarding that, my lord, delay, my lord. My lord, may kindly produce, my lord, one, my lord, that is the Gursevak Singh's husband, which, my lord, I have earlier, my lord, submitted, my lord. It is not related to, my lord, Narcotic Control Bureau, but it is, my lord, the related to, my lord, PC Act, my lord. PC Act, my lord. It is related to, my lord, PC Act, my lord, where, my lord, that is the Honorable Supreme Court granted, my lord, bail, my lord. Regarding the delay, my lord. Yes, my lord. In para 7, my lord. Only I am coming to that, my lord. One another aspect of the matter we need to highlight is that while considering the plea for anticipatory bail, why should the High Court ask a question to the investigating agency as to why the accused had not been arrested for the last 4 years? My case is, my lord, that is more than 4 years from the date of investigation, my lord. That is when it is started, my lord. And also, my lord, that is from the after filing of the final complaint, my lord, more than 3 years and 9 months, my lord. Why the accused had not been arrested for the last 4 years? The fact that the petitioner was not arrested for 4 years by itself was a good ground for the High Court to exercise its discretion and order grant to anticipatory bail. So this is a case, my lord. It is, my lord, from, my lord, the state of Punjab, my lord, and it is, my lord, related to Prevention of Corruption Act, my lord. PC Act, my lord, Special Act, my lord.
Okay.
So, my lord, my respectful submission is that, my lord, first, my lord, that is, my lord, I am not, my lord, related to, my lord, that is the contraband. I am not in the, my lord, the conscious or any kind of constructive possession of the same, my lord. Secondly, my lord, it is on the base of the 60 from the, my lord, that is the hearsay statement of one of the apprehended accused. Thirdly, my lord, it is based on a, my lord, the mobile phone communication which, my lord, investigating agency stated it is registered in the name of another person, my lord. Thirdly, my lord, though, my lord, they have filed the, my lord, final complaint, my lord, there is no, my lord, permission granted by the trial court. Neither they filed a separate application thereof, my lord. This is the, my lord, case, my lord.
Okay.
So at this stage, my humble prayer of before your lordship is that, my lord, in those cases, my lord, the custodial interrogation may not be required, my lord, or, my lord, if it is so, my lord, it will, my lord, influence his fundamental right. That is my humble, my lord, submission.
Yes, Mr. Dev. In complaint cases, I put a query to you on last occasion, perhaps.
Yes, my lord.
In this case, in complaint cases, where is the provision for filing an additional supplementary complaint? This query I pose.
Yes.
Though filing of an
But when the fact remains, Lordship, if investigation discloses something,
but
it may not be a supplementary.
it may be a new.
Because it's a case where
Yes, it may be a new complaint you can file.
it might be a new complaint because it is not a case like in the PMLA.
But presently, apart from the statement of Nazir, who disclosed the petitioner's name, what is the material?
Now, only for that purpose, if your lordship will see,
So
if your lordship will come to page 86 for a moment of his petition.
page 86.
Now, what has fallen from your lordship and mine is absolutely correct. It is a statement from one of the other accused persons that the petitioner herein was a purported receiver or some lordship. Now, how do we ascertain that? We have got to ascertain something. There is a phone number which is somehow related to the petitioner because a phone can be in anybody's name. Any other person can use it. Now, from 2022, your lordship is just consider. Lordship is not entertaining a criminal petition wherein the jurisdiction of the courts or the authorities is concerned. It is a purely simple anticipatory bail application. We are not on the point of jurisdiction. Now, since 2022, we have been issuing notices. You don't appear.
No, but you have to show that those notices were received by him.
Yes, only when lordship call for the records.
Yes, only issuance of notice.
Sir, and an objection, I say that we have issued notices. Lordship has to look into the records for that.
Yes.
But as of now, I would submit, Lordship, since 2022, the matter is under investigation. We have issued notices.
He has cited a case.
Yes.
where apex court has observed that if the only material after investigation is completed is the statement of co-accused.
So far as the petitioner is concerned, Lordship, that is not completed. Had it been completed, we would have filed the final complaint. It is not completed, hence, therefore.
No, therefore I am putting query to you.
Yes, Lordship.
Now, what is the stage of investigation with regard to the petitioner? Except the fact that you have not examined the petitioner.
We have not examined the petitioner, we have not been able to make out. Because there is a statement from the other accused that he is one of the persons who is.
Apart from that,
Lordship, I
there is nothing.
But we have to establish that. We have to establish that. Until and unless he comes forward, he does not come forward for 4 years. Now suddenly he appears that he will be arrested. Now, in the petition, Lordship, whether your Lordship will see any such statement, any such material, why he apprehends it now? For 4 years he is fine. For 4 years he is fine. And if your Lordship will see the judgment.
No, because there is a clear statement in the complaint that you have stated that supplementary complaint will be as and when he is arrested.
If I am wrong, if that is not permissible, that will have a separate cause of action. This was filed in 2022. This was filed in 2022. Why is it coming in 2026? There is no material in the petition to show that why he is coming in 2026. Is it a case that, oh, now I have become conscious? Now he has brought in all those court orders. From 2022, what were you doing? You knew all through. You knew all through. The decision so far as the Supreme Court regarding the delay, yes, but that is not applicable in the present case because you have not appeared. In spite of notices, you have not appeared. We have
No, what is the law as regards continuation of investigation in case of a complaint case? Once you file complaint, what law governs?
State caution. I have gone through the statute, Lordship. It may not be permissible to file a additional charge sheet. But will that preclude the authority from carrying on the investigation? It will definitely not, Lordship. He might have a case if we file it and that is not permissible under law. That would be a separate case. That would be a criminal petition. But that will not be decided in the case of anticipatory bail. Anticipatory bail, you are apprehending arrest. Yes. Why after 4 years? 4 years you did not cooperate. Now that you have come to court, we will definitely say we need your custody. Because since you are not available, we have not been able to progress. Suddenly, after 4 years, you pop up and say, I am apprehending arrest. It would have been a very good case had this application been filed in 2022 or 23 itself. That would have been a very good case for him. But now, after stalling the investigation, you come to the court. Now we know that you're before the court. Yes, we do need your custody. We do need to establish the facts against you if it is there. If it is not there, you're free.
Let him appear.
I leave it to you.
Heard Mr. K. Bashir, learned counsel for the petitioner. Also heard Mr. R. K. Dev Chaudhary, learned Deputy Solicitor General of India. representing the NCB is not representing the Union of India. This application under section 482 of the 482 of the DNSS 2023 has been filed by the petitioner, namely Shri Apuranjan Das, who is apprehending his arrest in connection with NCB Gauhati crime number 7/2022, corresponding to NDPS case number 202/2022 under section 21C/29 of the NDPS Act 1985, pending before the Court of London, Additional Sessions Judge number 4, Kamrup Metro at Gauhati. The facts relevant for consideration of the instant anticipatory bail application, in brief, are that the Narcotic Control Bureau filed a final complaint against two accused, namely Nazir Ahmad and Sadek Mia, inter alia alleging therein that 29,900 bottles of cough syrup containing codeine phosphate with brand name S-Cuff within inverted comma were recovered from a truck bearing registration number NL02 N6922 on 14/3/2022 when at National Highway number 37 opposite to Health City Hospital, Khanapara, Gauhati. In the final complaint, it is stated that the present petitioner in the final complaint, present petitioner is stated to be a suspect involved in the offense alleged in the said case. He is suspected to be one of the kingpin of the drug trafficking network and was suspected to be the main receiver of the seized cough syrup. It is those cough syrup stop. The learned Mr. K. Bushaw, the learned counsel for the petitioners, has submitted that in paragraph 70 of the final complaint, the NCPA has stated that as and when the suspected persons are arrested, supplementary complaint petition may be filed, which has caused apprehension of the petitioner getting arrested in connection with the aforesaid, above mentioned case. Learned counsel for the petitioner has submitted that the only material in the final complaint against the present petitioner is the statement of co-accused, namely, what is the name of that?
My lord, he is, my lord, one, my lord, Nazir Ahmed, my lord,
Statement of
Nazir Ahmed,
co-accused Nazir Ahmed,
who has disclosed in his statement that Jalil told him that the says cup syrup pertained to Apuranjan Das. It is, my lord, in the complaint itself, my lord, page 83, my lord.
who has disclosed in his statement recorded under section 67 of the NDPS Act that co-accused Jalil has informed him where page 80,
My lord, page 83, my lord. Page
Good.
83, my lord. Para 58, my lord. Sub para is, my lord, Roman 7.
ये last line के लिख रहे, who has told him that informed him that the seized cough syrup pertains to Apuranjan Das. Learned counsel for the petitioner further submits that the CDR analysis of the mobile phone of the arrested accused indicates, arrested accused, namely Nazir Ahmed, indicates that he was in touch with a person using mobile number 9837868388, which was used by the present petitioner.
No, my lord, that was not, my lord, my phone number. That was, my lord, that is Jalil's phone number, to whom, with whom, my lord, he is in communication. My lord, the apprehended accused person was not in with my communication, my lord.
Who is Guddu?
My lord, Guddu, my lord, I don't know, my lord. He is, my lord, another person, my lord, they stated, my lord, in the, my lord, my lord, entire, my lord, thing, my lord, he is there, my lord. My lord, Apuranjan's part is, my lord, that is in the complaint, my lord, page 86 of the petition, my lord, clearly stated, my lord. They surfaced this number from other, my lord, some case, my lord, from where they stated that, my lord, this is the number in connection, so it is used by oath. Even, my lord, there is apprehended accused person is not touched with that particular mobile phone number.
No, phone number of one petition, one Guddu.
Para 5 of the petition, my lord, I have mentioned, my lord, in short, my lord.
He further submits that though the NCB in its written objection has alleged that the phone number, the mobile phone bearing number 87981
Yes.
was used by the present petitioner for communicating with the co-accused persons. However,
It is registered in the name of one artist.
the said mobile phone number is registered in the name of one Atish Kumar, who is not known to the petitioner. He further submits that the petitioner never ever used the aforesaid mobile number. He further submits that the contention of NCB that said phone number also surfaced during the investigation by NCB in connection of a different case, that is Gauhati, that is crime number 2/2022, is also only to the effect that the NCBs only suspected the petitioner in that case. However, no evidence is there on record of the petitioner using the said mobile number. Learned counsel for the petitioner submits that the incident alleged in the above mentioned case had occurred on 13/3/2022, where as well as the final complaint has been filed on 5/9/2022, and more than 3 years, 9 months have lapsed from the date of submitting of the final complaint, however, the NCB has never obtained any formal order of the court for continuing with the investigation. He submits that even if the investigation may be continued after filing of a charge sheet in a police report case, the law requires that permission for continuing with the investigation has to be obtained from the court. He submits that same analogy may be applicable in complaint cases also. He further submits that in the instant case, apart from the statement of the co-accused, there is no other material on record to implicate the petitioner with the offense alleged in this case. As such, he submits that this is a fit case where anticipatory bail may be granted to the present petitioner. learned counsel for the petitioner further submits that the fact that after filing of the final complaint, more than 3 years, 9 months has lapsed, and the petitioner was not under any protection during this period, but he was not arrested during that said period, is in itself a good ground for this court to exercise its discretion to grant anticipatory bail to the petitioner. In support of his submission, the learned counsel for the petitioner has cited following rulings. Number 1, Pramod Kumar versus State of Uttar Pradesh, and another, reported in 2026 INSC 120. Number 2, Gursevak Singh versus State of Punjab, order dated 3/9/2025 in SLP in special leave to appeal within bracket criminal 11234/2025. Next, Sukhminder Singh versus Sukhvinder Singh, alias Sukhvinder Singh versus State of Haryana and others. Within bracket, order dated 23/8/2024, passed in special leave to appeal within bracket criminal number 6811/2024. On the other hand, learned Deputy Solicitor General of India, Mr. R.K. Dev Chaudhary, has opposed the grant of bail to the present petitioner on the ground that the quantity of contraband involved in the case is of commercial quantity, and therefore embargo of section 37 of the NDPS Act is applicable in this case. He further submits that the evidence on record suggests that the present petitioner is a prime suspect of having been the kingpin of the drug trafficking which is involved in this case. And considering the statement of the co-accused, which implicates him with his involvement in the alleged offense, bail may not be granted. He further submits that custodial interrogation of the present petitioner is necessary for a proper investigation of the case. He submits that though the NCB has not sought for any leave to continue further investigation in with regard to the pending NDPS case number 202/2022. However, there is no bar in filing a fresh complaint case if the NCB is able to collect materials against the present petitioner. He submits that in view of the judgment of the apex court in the case of Samarth Kumar, yours.
Yes, ma'am. Yes, there are 21,106 means that is the
In the case of State of Haryana versus Samarth Kumar, reported in 2022 SCC Online SC 2087. The evidentiary value of the statement of the co-accused cannot be considered at the stage of consideration of an anticipatory bail application. Stop. He has also cited following rulings in support of his submissions. Sumita Pradeep versus Arun Kumar CK, reported in 2022, 17 SCC 391. NCB versus Mohit Agarwal, reported in 2022, 18 SCC 374. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for both sides in support of their respective submissions. On perusal of the materials available on record, it appears that nothing was seized from the possession of the present petitioners. He is suspected of having been involved in the offense alleged in this case, mainly on the basis of statement of a statement of co-accused, namely Nazir Ahmed, who has claimed that he was told by another co-accused regarding involvement of the present petitioner. Stop. As apart from the statement of co-accused, at this stage, there is no other material. A statement of co-accused recorded under section 67 of the NDPS Act, which is otherwise not admissible in evidence. There is no other materials to implicate him in the offense alleged in this case. This court is of considered opinion that Under such circumstances, embargo of Section 37 of the NDPS Act 1985 may not be applicable to grant of bail to the present, anticipatory bail to the present petitioner. More so when, after filing of the final complaint by the NCB more than 3 years, 9 months ago, no leave of the court has been taken by the NCB to continue with the investigation. In the case where already final complaint has been filed. Further, next fella, the fact that even after filing of the final complaint more than 3 years, 9 months ago, why the present, why the NCB has not been able to arrest the present petitioner is also a question which may be asked. And this said fact is in light of the observation made by the Apex Court in the case of Gursevak Singh versus State of Punjab, Supra, is a good ground for this court to exercise its discretion for grant of anticipatory bail to the present petitioner. Under such circumstances, this anticipatory bail application is disposed of with a direction to the present petitioner to appear before whom he will appear. No, then we will not direct him to. If you arrest him, then you grant him bail. We will not direct him to appear before anybody. Whom? Before whom? Because no IO is there. Already you have filed final complaint. Neither you have taken leave. In the event, continue. Last line पढ़ा था. Disposed of with an direction that in the event the petitioner is arrested in connection with the offense which has been alleged in NCB crime case number 7/2022 or /NDPS case number 202/2022, he shall be granted bail of rupees 50,000 with one surety of like amount to the satisfaction of the arresting authority with following conditions. 2 conditions. So, with above observation, this anticipatory bail application is disposed of.
Deeply.
Order, Section 14.
The matter has been amicably settled outside court. So we are going to pay a further amount of rupees 9.5 lakh. In addition to earlier, we have already paid 14,91,542.
Any written Agreement has been. So this can be disposed of in terms of. Heard Mr. R. Sharma, learned counsel for the appellant. Also heard Mr. A. Bhattacharya, the learned counsel for the respondent number 3, insurance company. It is submitted by learned counsel for the insurance company that parties in this appeal have arrived at an amicable settlement with the amicable settlements. Stop. He submits that the insurance company has agreed to pay an additional amount of rupees 9,50,000 as full and final settlement to the claimants, in addition to the amount. How much you have already paid?
We have paid 14 lakh, that is
41 lakhs 91,540.
In addition to the amount which has already been paid, namely within bracket rupees 14,91,542.
542.
Stop. In view of the settlement arrived at between the parties, this appeal is hereby disposed of in terms of the settlement arrived at between the parties. The letter dated 22/6/2026 furnished of the 22/6/2026 issued by the hub in charge of the Appeal and Specialized Claim Division of the insurance company, which has been produced by the learned counsel for the petition insurance company, is marked as X and kept in the case record. When will you pay?
within a period of 4 months, 4 weeks.
The agreed amount of rupees 9,50,000 shall be deposited where?
Before the registry.
Before the registry of this court within a period of 4 weeks from the date of this order by the insurance company. On such deposit, same shall be disbursed by the registry to the claimants after proper verification.
Claimant number 1, Lordship.
Claimant number 1 after proper verification. This appeal is accordingly disposed of.
I pay for the respondent number 1 more. Because in this matter, services otherwise complete. So we can come up with hearing after the vacations.
None appeared for the appellant on call. Heard Mr. S. Vishwakarma, who has appeared for respondent number 1. On perusal of the office note, it appears that even Wakalatnama has been filed for respondent number 2 also. Hence, the service of, how many respondents are there? Service of, hence the appearance of service of notice on all the respondents is hereby complete, and it also appears that the records of concern MAC case have also been received. Hence, this appeal is ready for hearing. Let this appeal be listed for final hearing on 22nd September.
May I please?
May I please,
This matter may be listed for final hearing. My name is not reflected in the quasi-late matter. I am on behalf of respondent number 1, 2, 3, and 4, and also 5.
What is your name?
Yes, Ahmed.
A.S. Ahmed.
Yes, ma'am.
Heard Mr. B. Hussain, learned counsel for the petitioner. Also heard Mr. A.S. Ahmed, learned counsel appearing for all the respondents.
Mine.
All the, you are appearing for. Any other counsel is there?
My lord, another senior counsel is Mr. M. A. Sheikh. He is also on behalf of all the.
Okay, all the respondents. It appears that the service of that appearance of all the parties, appearance of parties in this civil revision petition is complete. What have you impugned?
Not in the short, that may be fixed, my lord. In this case, case already state further proceeding of the case is state. So in a short date may be fixed out here.
Let this matter be listed for hearing on 24th September. The interim order shall continue.
21st, my lord.
There is no interim order.
No interim order. Okay, 24th September.
Earlier, can they consider, my lord? Short date.
That is the shortest date.
I guess 17.
Wait, please, Your Lordship. Lordship, as per office note dated 17/6/26, respondent 1 has filed wakalatnama. AD card of 2 has not been received, but LCR not received, but we had taken steps by both ways. So the report of process server is not given. But the steps were taken long time back, 24.
You have to take fresh steps against
By speed post or?
by speed post against 2. Heard Miss R.D. Majumdar, learned counsel for the appellant. On perusal of the office note dated 17/6/2026, it appears that the engaged counsel for the respondent number 1 has filed wakalatnama. However, service report in respect of notice issued to respondent number 2 is awaited. Since the notices were sent to respondent number 2 long back, the petition appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 3rd of August. Let a reminder be issued for the records of the concerned motor accident claims case from the concerned tribunal.
So Kamrup itself, Lordship.
Registry to do so.
Tell your pleasure.
List accordingly.
My pleasure, Lordship. Lordship, as per office number 17/6/26, Lordship, 1 to 5, they have filed wakalatnama, Lordship. And regarding 6, no AD card or answer notice has been received. And regarding 7, Lordship, it is service is complete, Lordship. So far as Lordship, respondent number 6 is concerned, service report may be awaited, Lordship. Because notice was issued on
back.
13 to 25.
You have to take fresh steps. Heard Miss M. Chaudhary, learned counsel for the appellant, learned counsel for the applicant. This is condonation petition.
No, Lordship. So appeal was already admitted, Lordship.
Learned
It's
counsel
a stay
for
petition. Notice was issued on
learned
stay also.
counsel for the appellant / applicant. It appears from office note dated 17/6/2026 that engaged counsel for respondent number 1 to 5 have filed wakalatnama, whereas AD card sent along with the notices issued to respondent number 7 have been received, has been received back with signatures of the said respondent thereon. Stop. The notice issued to respondent number 7 is, therefore, held to be duly served. However, no service report in respect of notices issued to respondent number 6 is awaited. The appellant is directed to take fresh steps for issuance of notice upon respondent number 6 by speed post within 7 days from the date of this order, returnable on 3rd of August. Please.
Stabilize those.
Item 19.
May it please your lordship, in this matter, the TCR has not yet been received, my lord. As per office note dated 17/6/2026, second reminder for TCR has been issued, my lord.
Lord Miss S.E. Murtaza, the learned counsel, appearing for the appellant. Also Mr. T.R. Gogoi, learned government counsel, appearing for respondent number 7 and 8. What happened to on perusal of the office note dated 17/6/2026, it appears that though the second reminder for trial court records have been issued to the concerned trial court, however, no response has been received in that regard. Let a fresh reminder be issued for trial court record registry to do so. Let this matter be listed 3rd of August.
Oblige.
20 and 21.
May I please your lordship? In this case, lordship, learned additional advocate general D. Mazumdar, lordship, he has suddenly failed annual, lordship. So, that may be fixed after vacation, lordship.
23rd, lordship.
23, lordship.
Miss D.D. Burman, the learned additional senior government advocate representing the review petitioner in review petition number 292/2022 and 293/2025, who submits that the senior counsel appearing for the state of Assam, namely Mr. D. Majumdar, is not well, and on that ground an adjournment is prayed for. Also Mr. S. Deka, learned counsel for the other side, as well as Mr. M. Nath, learned senior counsel, assisted by Mr. A. Bhattacharya, learned counsel for respondent number 2, who does not raise any objection. Hence the prayer is allowed. Let this matter be listed on
23rd.
23rd of
July.
30 July.
30th.
30th.
Item number 23, 22 and 23 similar.
Yes. Common order.
Common order. Oblige.
Item 24.
May it please your lordship. Lordship, kindly take up the IA number 2008 of 2026. Lordship, we may be given some time to file our objection.
Combination.
No, no, this is not confirmation. They have filed this I for withdrawal of the deposited amount here.
Award, 50%.
50%.
Third Miss, what is her name?
D and Das,
Third Miss D and Das,
on behalf of D Mohanka.
appearing on behalf of Mr. D. Mahanta, learned counsel for the applicant. Also at Miss P. Bhattakur, learned counsel for the insurance company, who prays for some time to file written objection against the instant interlocutory application filed by the petitioners seeking withdrawal of the 50% of the awarded amount deposited by the insurance company before the registry of this court in pursuant to the directions of this court. The prayer is allowed. Let this matter be listed when? 31st of July.
Obliged.
Item 25.
What has happened to the make appeal?
The main appeal, your lordship, service is completed. Respondent number 1 to 5 has already entered appearance, and the respondent number 6 and 7 has already been struck off, your lordship, and LCR has been received.
Lordship, appeal memo may be served to us.
We have copies.
We have not
Third
received.
Miss P. Bhattakur, learned counsel for the appellant, also heard Miss
D and us.
D. and Das, appearing for Mr. D. Mahanta, learned counsel for the respondent / claimant. This appeal is ready for hearing. The appellant is directed to furnish a copy of memo of appeal along with annexures to the learned counsel for the claimant respondent before the next date fixed. Let this matter be listed for final hearing on 24th September.
Obliged.
Item 25.
Next, your lordship, an application praying for delay of continuation of 163 days, my lord.
Ms. L. Wazida, learned counsel for the petitioner. This application under Section 5 of the Limitation Act has been filed for condoning the delay of 165 days in preferring the connected civil division petition. Issue notice to the respondents. The petitioners shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 3rd of August.
Obliged, your lordship.
Item 26.
Wait, please, your lordship. Lordship, I filed this I, lordship, the applicant is the son of the claimant, lordship. The claim will expire during the pendency of the appeal, lordship. The appeal has already been disposed of, lordship.
Appeal has been disposed of.
Yes, lordship.
Then
Judgment has been passed. After that, we came to know, lordship. The claimant has expired, lordship. Now the son is the applicant, lordship. Amount has already been deposited, lordship.
any objection?
No, your lordship, I have no objection.
Heard Miss P. Barua, learned counsel for the applicant, also heard Miss P. Bhattakur, learned counsel for the
In this application, your lordship, respondent number 1.
respondent number 1 insurance company. This interlocutory application has been filed by the applicant praying for allowing the present applicant who is you are the son.
Yes, lordship, sir.
Is there any other son?
No, lordship.
Any other heir?
Next of kin certificate, lordship. Page 26, 27.
who is the son of the claimant who has died. When
The claimant expired on 16/12/2023, Lordship. That certificate is annexed.
16/12/2023. It is submitted by learned counsel for the applicant that MEC appeal number 171/2012 was disposed of by a coordinate bench of this court when
16/5/2025.
on 16/5/2025 and in pursuant to the direction of the court, the insurance company has also deposited the awarded amount before the registry of this court. As such, under the circumstances, facts and circumstances of this court, this case, she submits that the present applicant, who is the sole heir of the deceased claimant, may be allowed to withdraw the awarded amount deposited by the insurance company in the registry of this court. In support of her contention, the in support of the contentions raised by the learned counsel for the petitioner, the death certificate of the deceased claimant and next of kin certificate of the deceased claimant are annexed along with the instant interlocutory application. Ms. P. Thakur, learned counsel for the insurance company, does not raise any objection against the prayer. So, in view of the submissions made by the learned counsel for the applicant, as well as after considering the material documents annexed along with this interlocutory application and the averment made therein, the prayer is allowed. The registry is directed to disburse the awarded amount which has been deposited by the insurance company in connection with MAC appeal number 171/2012 to the present petitioner, namely, what is her name? Petitioner
Lordship.
Devashish Dev,
Devaship.
who is the son of the deceased claimant, after proper verification. This interlocutory application is accordingly disposed of.
Public.
Item 44 from supplementary list.
Chief, as for office note, Lordship, despite taking fresh step, notices remain unserved. So I may be allowed to go for dusty service, Lordship.
With against whom?
Yes, Lordship, for A, B, C. The substitution petition, Lordship.
Heard Mr. A. Islam, learned counsel for the appellants. Also heard Mr. G. Bhardwaj, the learned counsel for
Respondent number 1, 2, and 3.
respondent number 1, 2, and 3. You have filed a substitution petition on. Have you filed?
Lordship. IA number 2331.
2330. Common order. And what is 2331?
2331, Lordship, this is IA for substitution. And 2330, there is a delay. That is why a continuation delay petition was filed. The IA is for continuation.
in 2330. The 2330 sum. Learned counsel for the applicant has submitted that the notice issued to respondent number 4A, 4B, and 4C could not be served, hence served by usual mode. Hence he prays for taking fresh steps for service of notice on the said respondents. The prayer is allowed.
Lordship, I am praying for dusty service.
Additionally, speed post plus dusty. The petitioner is directed to take fresh steps for issuance of notice upon the above mentioned respondents by speed post within 7 days from the date of this order, returnable on 10th of August. The petitioner is also allowed to additionally take steps for service of notice upon the above mentioned respondents by way of dusty mode. Stop. In the event the petitioner is able to serve the notice on the above mentioned respondents by dusty mode, and an affidavit in compliance thereto shall be filed by the applicants on the next date fixed. List this matter on 10th of August. 10th of August.
That is on item 8.
This appeal under order 43 is deferred against the order dated 16/3/2026 passed in Mizek case number 63/25 arising out of 41/25 filed by the petitioner plaintiff. The petitioner plaintiff filed a suit along with an injunction petition. The defendants contested the suit separately. Defendant number 1 and 2 and defendant 3 to 4, 5, 3 to 5. We also filed the injunction petition. Initially, injunction was granted. Subsequently, after hearing the parties, injunction was rejected. At rejection order, it was at page 311.
Mr. Jain, you are appearing for
David.
all the respondents. We'll admit the appeal.
Lordship. Only thing is, that means injunction order now, there is no injunction order. We, as regards to the injunction,
We'll hear the matter on the next date.
finally,
Because he has appeared. It is only against rejection of an injunction.
only thing, problem is that by then they will construct and we will have no say. Because by deciding the injunction petition as if the suit has been already decided by the Honorable Court.
Lord Mr. B.K. Bhagawati, learned counsel for the appellant. Also heard Mr. B.K. Jain, appearing for all the respondents. This appeal under Order 43, Rule 1R, read with Section 151 of the Code of Civil Procedure, 1908, has been filed by the appellants, impugning the order dated 16/3/2026, passed in Ms. J case number 63/2025, arising out of title suit number 41/2025 by the Court of Learned Civil Judge Senior Division Number 3 Kamrup Metro, whereby the prayer for grant of temporary injunction by the present appellant was rejected by the trial court. Since Mr. Jain has appeared for all the respondents, no formal notice need to be issued to the respondents. You have received the copy of
Yes. By filing TBF, they furnish the copy, ma'am.
it is submitted at bar that whether records would be necessary.
No, plus.
No. You have annexed everything.
Yes.
It is submitted at bar that this matter may be finally heard for disposal on the next date fixed. Accordingly, let this matter be listed. July. Let this matter be listed.
Subsequent to 23rd July,
After 20th.
immediately after that. Will be
Let this matter be listed on. Or we may fix it in the first week of August. First week of August. Fourth of August.
For hearing another 41, item 11.
Might be the way.
Yes.
In this case, the appellants are lordship plaintiffs. They filed a suit for specific performance of contract lordship. The case of the plaintiff is in page 21 for a moment, lordship. Paragraph 8, lordship. This is the original plaint, lordship. That the predecessor in interest of the plaintiff agreed to transfer the land for the inauguration and construction.
You are plaintiff or defendant?
Plaintiff, lordship.
Okay.
This is our suit, lordship. Both the courts dismissed the suit, lordship.
Okay. What substantial question of law is?
Page 8 and 9, lordship. Substantial question number 4, lordship, whether the learned trial court committed wrong in holding the exhibit 2 as not admissible after holding the same to be a valid document while deciding issue number 3.
What is exhibit 2?
Exhibit 2 is the document by which defendant number 1 agreed to return back the land to the predecessor of the plaintiff. So on the basis of exhibit 2, the plaintiff filed the suit for specific performance of contract.
What was the contract?
Lordship, first, we have my predecessor sold out the land to the defendant number 1 for construction of an school, and thereafter defendant number 1 on the same date executed another deed of agreement, said that if the school was not constructed, then I will return the land by executing a sale deed.
This is exhibit 2.
This is exhibit 2, lordship. So page 49, learned trial court held that the exhibit 2 is valid. This is genuine. But lordship, as the original was not submitted as exhibit, only certified copy was exhibited. So on this ground, this says that this is not admissible. But lordship, there was no objection from the respondent side while exhibiting the document. So this substantial question of law number 4, lordship.
Yes. Ms. Barua, you are appearing for?
Yes, 23, lordship, for Inspector of Schools and Director of Secondary Education. Lordship, it is the school respondent number 1, lordship, who should, the petitioner is agreed upon, lordship, should intervene, lordship.
Heard Ms. R. Chaudhary, the learned senior counsel assisted by Ms. S. E. Mortaza, learned counsel for the appellant. Also heard Ms. R. Barua, appearing for respondent number 2 and 3.
Government advocate is there, Lordship. State of Assam, respondent number 4, and cause list also reflected name of government advocate, Lordship.
For 5,
For respondent number 4 and pro forma respondent number page 6, Lordship, 25 to 28.
who is appearing for 5? 4. 1. Notice will go to 1.
Yes.
Except 2 and 3. Stop. After considering the submissions made by learned senior counsel for the appellant, and after going through the materials on record, following substantial question of law is formulated in this regular second appeal. Whether the judgment of the trial court as well as first appellate court were hit by perversity in dismissing the suit without taking into consideration the Exhibit 2 agreement, holding it to be not admissible, though making an observation that same is a valid document. This would be enough.
Yes, Lordship. And
Issue.
there is an admission by DW1 that the lands which were not utilized by the school, those were returned to some of the landowners, Lordship. So there is an admission by the DW1 which was also not taken into consideration. My land was also not taken into, not utilized by the school, so it has to be returned to the plaintiff, Lordship. That aspect was also not taken into consideration. So a substantial question of law 2, Lordship.
Number 2. Where is that substantial question?
Page 9.
Which one?
Whether the findings arrived at by both the learned courts are at all correct in presence of Section 53 of the Bharatiya Sakshya Adhiniyam.
Is 53?
That is 58 of the Indian Evidence Act. Admitted facts need not to be proved.
Whether, next number 2, whether both the courts below committed perversity in dismissing the suit of the appellant and affirming the said dismissal by the first appellate court in ignoring the admission by the defendants side that the land which were not utilized for the purpose of the which school?
Garamari, Lordship, that is Garamari High School, Lordship. Garamari ME School at Village Garamari, Lordship.
Purpose of Garamari ME School at Village Garamari. Second, only second. Perversity. Were returned back to the owners from whom they were procured. However, same was not done in respect of the present appellant. Stop. This much is enough.
Yes, Lordship, DW one is assistant teacher in the Garamari High School. I'm sorry, Lordship, I have said Garamari ME School.
High school instead of issue notice to the respondents. Since Ms. R. Barua has already appeared for respondent number 3 and 4, 2 and 3, no formal notice need to be issued, said respondents. You have received the copies. As regards the other respondents are concerned, the appellant shall take steps for issuance of notice to the remaining response to them by speed post as well as by usual mode within 7 days from the date of this order, returnable on 10th of August. List
No
according.
formal notice will be required in respect to respondent number 4, 25, 26, 27, and 28.
Why?
They are GA Assam, Lordship.
You have served notice.
Yes, Lordship, cause this reflected their name.
Stop.
So extra copy I will serve.
With regard to respondent number 4 and
25, 26, 27, and 28.
25, 26, 27, 28.
Page 6.
The learned senior counsel for the appellant submits that notice has been duly served to the learned government council. Hence, no formal notice need to be issued to the said respondents. However, the appellant is directed to furnish requisite numbers of copies of memo of appeal along with annexure to the London Government Council within 7 days from the date of this order. List accordingly.
Obliged.
Next item is mine item, my lord, the under order 41, rule 11, my lord. Other side has already started execution case. So may I pray that it may be listed tomorrow at 2 p.m.
Item number?
12.
Item number 12. Due to paucity of time, this matter could not be taken up for hearing. Considering the urgency involved, let this matter be listed tomorrow, that is on 24/6/2026 at 2 p.m.
Alia, my lord,
Alia.
this is my lord. Item number 45, my lord, was probably my lord in the morning. It was mentioned in my absence, my lord. My lord, it's 2019 matter, my lord, where I am in suffering, my lord. Can it be on some other early date, my lord? Any other date early, my lord? It was fixed on September.
Item number 45 already.
My lord, it was mentioned, my lord. I was given an idea that it will be immediately after vacation, my lord, but a date was taken a very long that way, my lord. Can it be in any other date earlier than that, my lord?
Who is for the other side?
My lord, I have taken the consent from Mr. Ajay Shukia, who is from the other side, my lord. I have called him up and I have taken consent from him. I have intimidated him. And he said there is no problem. It can be fixed any date after the vacations, my lord opens any date for me.
What was the date given?
My lord, 21st of my lord September, my lord. I was intimated. It was 17th September. I'm sorry, 17th September. Sometime in the
For
month of
hearing.
July, my lord.
Hearing will go to September.
My lord, August, my lord, any date, my lord. It is 2019, my lord.
We do not have dates. We wait till 17 August.
Item number 30, my lord.
Item number?
30. It's a 2013 matter. Nullly date may be kindly. Item number 30. The matter is pending from 2013.
13 early dates of. Early date means it will go to September.
August.
And then we will direct registry to list it after 4 weeks and it will upon the registry. If we have to give dates, it will go to the month of September only.
Maybe.
We will.
The fixed date is better.
We will show the hearing matters as leftover matters. We will request the registry to accommodate the dates instead of fixing dates in the month of September.
Lordship, may I make a query in item number 59?
In item number 39, on the last three occasions, the matter couldn't reach due to paucity of time. There is a IA pending regarding the withdrawal of the 50% that has been deposited by the insurance company. Lordship, this IA may be heard, Lordship, in an early date because the applicant is facing financial hardship, Lordship. The 50% has already been deposited, Lordship. The IA has maybe heard. Any short date, Lordship, regarding the IA?
3rd August.
Lordship, July, Lordship, this order matter in the month of July after vacation.
If I fix in July, you,
because
on that
50%
day,
is
you will
already-
again at 4:50 PM, you will be standing like this.
Lordship, with
There-
regard
therefore-
to,
Orders matter.
Lordship, with regard to item 13, Lordship, that's hearing under 41(2), Lordship. So can it be less immediately after vacation, Lordship? Because I'm not burdened, Lordship, with this in these 3 days, Lordship.
13
Yes,
after vacation,
on 14 or 15, any day. 24.
24. Remaining leftover.
Lordship, item 39, Lordship may pass an order regarding hearing of my IA. Otherwise, it will come in the hearing section of. Lordship may kindly observe in the order. In item 13, Lordship.
I okay.
May I please, Your Lordship? Your Lordship, item number 33. Here the problem is that the mother is the claimant and there is possibility that he may not be in a position to enjoy the fruits of the award in her lifetime. So if Your
No,
Lordship can
why-
accommodate
You have to wait.
old ailing mothers, Your Lordship. Parents are the claimants.
Court master will accommodate.